So sorry for all inconvenience. So our session chairs, Professor Ashok Hampi, Mr. Sandeep Gargi, all dear presenters, participants, invited guests. Good morning, everyone. So first of all, I would like to thank IBBSA and IIM Bangalore for inviting me to present a research paper on this insolvency and bankruptcy. So let me give my brief introduction about myself. I am an agribusiness management graduate with BSc in agriculture from University of Agricultural Sciences, Bangalore, and from College of Agriculture, Mandya. So it is just around 100 km from here. And then I did MBA in agribusiness management. I also did 1-year executive program from IIM Indore. Currently, I am pursuing doctoral in business management program from SP Jain School of Global Management, which is actually a means you can say weekend or distance mode program. Then currently I am working with PwC India and based out at Delhi NCR. So without wasting any further time, I just run to the slides. So overall, the flow of presentation would be like that. Obviously, the topic, how I have arrived to select my topic, and what would be the objective and motivation behind this study. Problem statement, hypothesis development, research design, methodology, data collection, finding, and obviously what conclusion or recommendation I would be arrived at. So, as we all know that MSME is one of the most topic which is currently discussed by most of the stakeholders across the country. And our finance minister, she has also mentioned that MSME is the growth engines of the Indian economy, which is of course contributing around 50% of the exports and nearly 25 to 30% of India's GDP contribution. And obviously it will be helpful in realizing our dream, that is becoming the self-reliant India, that is the Atmanirbhar Bharat. And you all know, we all can understand that these MSMEs, they are, as of now, I can say it is scattered, and there are a lot of challenges and complexities which MSMEs are facing in terms of credit risk, market risk, reputation risk, default risk, at sectoral level, at firm level, at regional level, and obviously at national level, I can say. And now we are living in the globalized economy, so obviously the global factors will into the crucial role here for the success and survival of the MSMEs. So we need to change here. Then obviously this challenges, it is a complex one. And I can recall from the yesterday's discussion, the punchline what Professor Vikrant was saying, that the less is more. So here you can say the problems are complex. So obviously the solution what we can recommend, obviously it is also going to become a complex one. It cannot be the simple one. But yes, whatever the solutions we can generate, it can be in a simplified way. So there we need to work. There we need to work actually. And one of our finding is that obviously the 35 to 40% means out of 10 units, only the 6 units they are enjoying the formal financial channels. So whatever the schemes are and the benefits what Indian government is providing, so those 4 units out of 10, it is completely untouched. They are not getting into that formal financial channels. So that is also one of the things which we need to assess and which we need to analyze, and what best support we can go or we can provide to those 40% of the units that are surviving in India. Yeah. So what actually excites me, if I take as an example, or that we have listened yesterday also through the discussion, what Professor Vikrant was mentioning about two industries. One was the hospital and other was the shipping industry. So the same thing, because if you know, or if we categorize that how the set of talented doctors, how they run the hospital, particularly in case of emergency ward, whenever the patient comes, so what they do, they categorize those patients into the three different levels. One, maybe you can say A, B or C category. The A category would be, means they are at such a difficult stage that after putting all effort, it is not possible to save them. Second category would be the B category, that I will come later on. And the C category, that is the one category where this patient doesn't require much attention. Even with a small medication, even with a small effort, that patient can sustain and can survive. But the category like B, which doctors also realize, if you put even bigger or even a smaller effort, that patients can be saved. So here the same thing applies with the MSME. We need to prioritize this B category entity of MSMEs, where a government effort is needed, along with obviously the other stakeholders, other relevant stakeholders. So this is one of the motive, I should say, is exciting me or fascinating me to take it such topic here, and which I am extremely happy to be present at IIM Bangalore at this research conference. So coming to the problem statement and hypothesis development, as we all know, and government has also taken a step in the form of DG locker that she has already announced in this recent budget. What is this DG locker in fact? Some sort of documents, critical documents. All these MSME units they can store. They can store in that locker, and then these documents can be shared securely through online mode. So I think this is one of the most welcome steps, particularly for those entities who are newly born. Their business model is unique, but definitely they can contribute a lot to the Indian economy. So I think this particular step can help not only with the MSME firm or with the entity, but also for the lending agencies. So this is one of the things I think which we can take care of and can give further step to resolve it. And what I mentioned already, that this divide of document obviously it doesn't hold for the new entity. It can be an issue for the bigger entity, but it cannot be the issue for the new entity. And how to minimize the biasness? Suppose if any firm they approaches to the lending agencies, there are a lot of factors played for raising the credit, even for disbursal of the loans. All these complexities they happen. So my point here is that how these lending agencies they do overall credit appraisal process, so that some sort of biasness that can be minimized. So whether these lending agencies they consider all the factors like the financial factors, non-financial ratios, and in fact the other alternatives which are available on the social platform. So whether these lending agencies they are doing exactly the right credit appraisal process, so that an MSME firm they can avail a right credit at an affordable or the reasonable rate of interest. So these all things it needs to find out. The second hypothesis, which at the receiver end, that is the MSME end, that whether this MSMEs they are adopting the digital innovativeness, whether they are doing enough so that they can sustain the global challenges what what really Indian MSMEs or Indian business units they are facing. So this particular second hypothesis is more or less related to the receiver end, that is the MSME end. So, coming to the next slide, here we have listed certain variables. If you can see, certain variables means the data which we are going to train, the data which we are going to test. So these variables, they can comprise of from the financial angle, from the non-financial angle, and from the other alternatives where maybe some social platform or some other word of mouth or something, from there we can generate the data. So all this data at the means independent means which data which we are going to feed it to the system to train the model. So this will come under the part of independent variable. If you see the dependent variable, which is the output part, so mainly this output, it is at the two level currently. One is whether the firm, that is the MSME firm, whether they are enough to sustain the risk, the ongoing risk, or any global challenges which MSME firm can face, whether they have enough adequate capital infusion or means the capital backup, or they have the adequate collaterals so that they can survive. So all these things will come under this output. And obviously the second part, that is the bankruptcy. So output here, it is of two levels. One, that is the firm risk bearing ability, and the second, that is the bankruptcy prediction. So bankruptcy prediction, it is again, it may that in a certain time or maybe within the near certain period, there will be a probability of MSME or any firm they can default. So again, coming back to the point what we have discussed yesterday, I think Mr. Jayanti Prasad, who raised an issue very clearly, that now most of the initiatives, most of the schemes, they are mainly to cater to the need for the default MSME firm, but not for the firm who are going to default immediately or maybe within a certain period of time so that they can be saved. So we are not talking at all to that firm. So this is one of the challenges, and I think we need to raise it up right now, because still the impact of pandemic, it is not yet over. Somehow that cloud is still hovering around. So we need to be very cautious to raise those issues which MSME firms are facing, or may they can default maybe within 1 year, 2 year, or 3 years window, as we are facing, the sustained war of Russia-Ukraine, or we are having the disruption of supply chain, and all these, immediate or maybe any alarming situations or any alarming issues. So coming to the methodology part, which I've already highlighted, since the output is of the two level, it's mainly a categorical kind of level, means where we are categorizing that whether MSME can default or not, or whether they would be sustained enough to come into the main platform, and then they can face any sort of challenges which may come. So this classification analysis, particularly we have adopted to finalize this paper. So this classification analysis we have done mainly to identify those respondents that will come in the later part of the data collection and all. Mainly those respondents, it would be categorized further in two extremes. One would be from the lending agencies, that would be the supplier part, and one would be the MSME firm, that would be the receiver part. So that I will see in the later slides. So again, we have bifurcated, and we were very it's a kind of convenience sampling. We have very focused, our approach is a little bit focused. We have identified certain respondents, those who have already built the sanctioning process, assessment for the credit appraisal for those MSMEs. So all those things, it has been taken care of. So I will not take much time because we have also the Q&A session. So what we did, I will take just 1 or 2 more minutes, that how I have arrived with the certain findings and how I have collected data and all. So initially, we have approached 250 respondents from both the sides, from the receiver and the supplier side. And basis that, we have identified, we have listed few set of questions. That set of questions is similar for both the respondents from both the ends. So surprisingly, when I come to the findings part, so here with this slide you can see which would be the best factor in fact for MSME to sustain or for a lending agency to infuse the credit to that MSME firm. So when I asked this question from the respondents from both the ends, 40% approx, 41% respondents from the so if you see here from the bottom side, so 41% from the supplier side, means from the lending agency, they are also saying that it is the last 3 to 5 years of the firm performance that we usually analyze. That we usually analyze to come into the result. Is this correct? No.
Please continue, you are audible.
Am I audible?
Yes.
So when we see the response from the receiver side, so they are also mentioning the same thing. Means approx 56% they told that it is a reputation of the firm, and approx 22%. Sorry, approx 56% they are saying that this is the last 3 or 5 years of performance of the firm. That MSME firm, they are saying that this is the most crucial factor of their existence. Means the last 3 or 5 years of performance. So again, the next question which comes in our mind, okay, that is correct. So what the next factor could be? So the next best factor, what they are saying, that it is the collateral availability. Because most of the lending agencies, they don't give the fund as it is. They assess all the collaterals. Even for smaller ticket size of loan, maybe 5 lakhs, 10 lakhs, 15 lakhs, they take adequate collateral and then only they fund it. So it is highly critical for the new bond entity, because they don't have the sufficient collateral, they don't probably possess all this document of the last 3 years or 5 years performance. So these are some of the factors which we need to analyze. So this is again one of the findings. So next question which comes in our mind, okay, what would be the main factor then? One, because of that MSME can become corrupt or may become default. So lending agencies, they are also mentioning it is the intent of the MSME firm owner. It is their intent. They may go enough to analyze all the market situations, all the external situations, and then they can come and analyze their business, that how best they can perform. So again, response from the supplier side and response from the receiver side, from both the sides we are getting the same response, that it is the MSME firm owner or intent, whether they are really interested to make their business profitable. So that's all from my part. In fact, some of the limitations obviously I mentioned here, that of course it is a self-administered questionnaire, and we can further validate our findings with other mode of data collection, with other method of means AIML based analysis like logistic regression and other part like means all factoring and everything, which we can inculcate, and then we we can use other advanced GPT method to validate this finding. That's all.
Sir, can you give some practical examples where there is a use of AI in risk assessment?
See, I think I forgot to mention one of my research paper. It is also published in Risk Journal (NDPL), where I did contribution on digital credit scoring for rural lending. So most of the banks they have adopted. Actually, I can say 60 to 70% of the filing in sanctioning world, they are taking the help of AI.
Is there any algorithm or something so that we can
It is there. It is there. Suppose, say for example, if I take the example of Mahindra Tractor. So what they do? They have developed an app. Most of the field assistant, that the field level guys, they visit the farm. They just take the photographs. They just pick the videos of 5 or 10 minutes maximum. They upload those videos to the app, and then the value and everything it is generated within 30 minutes time. So within 30 minutes, the field level credit officers, they can evaluate, they can assess the value of that use time. So this is already happening.
especially credit risk or something?
Yeah.
Use of artificial intelligence in credit risk.
Yeah, that's what I told. In use tractor room. It is already in usage. And in other parts also. Suppose now you are getting personal loan in 2 minutes. How it is happening? It is through that enabled platform only.
Sir, to add upon,
One question I just want to ask you. You have mentioned in detail about that MSMEs and personal data input which is required. Data input is something which is very critical to any MSME. It's not easy.
Correct.
And once you have the data for 5 years, even a basic intelligence can say whether it requires this credit or not. We don't have to go through the artificial intelligence process. So, what we want to know is whether you have any system by which, without any data, you will be able to determine this requirement.
Yeah, see.
And second thing is, in all the cases wherever credit is required, we need a sacrifice from financial credit. Something extra which they have to do and which their regulatory authority will not permit.
Right.
So there are no such things where regulatory, the financial creditor will try to cross the line and give you something more than their warranted.
Right.
So these are the issues which are actually for troubling the MSMEs and also the financial credit. How do you try to reconcile these two opposite
Right. So coming to your first part of the question, you can see the hypothesis first one. It is clearly mentioned whether lending agencies in India, they are considering all the factors. All the factors means financial, non-financial, and other alternatives. So all the things which you have mentioned here, it comes under the other alternatives. Other alternative means, suppose a newborn entity, they don't have the backup of last 3 years or 5 years document. So how they will do? So whatever the data it has been generated for that particular form in readily available social platforms, I think those data lending agencies can also take it up for their decision. Right? So
This is the point which is not clear,
okay.
not coming out.
Yeah.
Like, you have taken the input
Yes.
from after asking the questions.
Yes, sir. Yeah.
So that is the input.
Yes.
The input should be the readily available data. In your case, input is the survey questionnaire.
Yeah.
So when a model has to predict that those questions will not be available, answers to those questions will not be available. So input variable should be something which is readily available,
Correct.
which I find missing here.
Right. So,
And second part, do you find this sample of 250 sufficient for artificial intelligence based deduction?
Certainly not, sir. So coming to your first question, what you told about the data which should be readily available means that of course you are it is one of the missing part in this paper. So I just wanted to answer here that there are two things. One, we need to train the data, and one, we need to test the data. So the trained data, obviously, whatever the data is available, maybe historic, from the historic point of view, whatever the data is available, so that data we will train it,
and then we will test the data from the data sets. So that testing of the data which will validate from the model constraint data. So certainly for this means this other alternatives like the data which is not readily available socially or anywhere else, certainly those data will not come. Okay, and those data will not be captured here. But yes, whatever the historic data would be available, that certainly can be modeled, that certainly can be trained. And basis this.
You have not built the model based on that data. You have built the model based on responses to the questionnaire.
Yeah, correct. So this.
How will those responses be available? In case those responses will not be available on the different topic.
Yeah, no. So for getting those responses, definitely we need to reach those respondents, respondents, and then we can collect those data from them.
So we can take it off here. So thank you, Mr. Anil, for the wonderful presentation, and I thank the audience for the questions. So next up, we'll move on to paper 2, which is fairness and equity in corporate processes under the code. So the presenter here is Mr. Virendra Kumar Gupta, who is an ex-member of the Income Tax Appellate Tribunal and the National Company Law Tribunal. So welcome and
Start?
Yeah.
Okay, thank you.
I mean, you don't have to do anything with the mic. It's audible.
It's audible, okay. Now, I'm not very familiar with these systems, so it will be a little bit. So the subject is fairness and equity in corporate process under the code. That is the subject which is gaining attention of the world. Particularly, so many people are coming, and in view of the more liquidations and large haircuts and no guidelines for the conduct by COC.
Sorry, can you wear the mic so it's not...
निकल गया फिर ये. Bankruptcy laws have been prevalent in global world for quite long, and in India also in different formats. There are two approaches, which are, one is pertaining to traditional approach, and there is the procedural approach. So in traditional approach, the role of adjudicator or judicial or the court is more, and the focus is on continuation of going concern. As compared to that, the proceduralist approach is market-oriented and a very little or I can say limited role to the adjudicating authority and the judicial processes. Based upon these two approaches, the IBC has been designed, and there are two marked changes in the paradigms. First is creditors in control approach as compared to debtors in possession approach. And another significant change is that from inability to pay, the paradigm has shifted to default. So there may be a short-term mismatch in cash flows or otherwise also, but if the default occurs, then you are bound to admit. The uniqueness of this structure of IBC lies in one more changes. Based upon the experience of SEBI, in 2002, Supreme Court found that SEBI was the regulator, SEBI was the adjudicator, SEBI was the supervisor. So some observations were made, and based upon that, the structure of IBC has been changed. The commercial process is being controlled, designed, and monitored by financial creditors. And the regulatory process and some part of delegated legislation is taken care of by IBBI. And the integrity of the process is being looked after by adjudicating authorities. So the processes which are there in the IBC are generally two processes which come into play, is the CIRP and the liquidation process. Different actors have been designed and institutionalized to achieve those, conduct those processes and their specific roles. So in this background, now the question comes, the fairness and equitable considerations in the corporate process under IBC. as you know that the principles of natural justice have been practiced, may not be codified, may not be written in so many words, but it is ingrained in human conscience. And those are the things one should be treated fairly. The treatment which we want to get for ourselves should treat the others in the similar fashion. So originally, two natural principles evolved. That was nobody can be a judge in his own case, and audio alterum partem. Here the other side. The extension happens when the evolution of the society and civilization. These two principles were added. First of all, these principles were applied to judicial proceedings, and thereafter, the reasoned order, necessity for reasoned order, and keeping records also emerged, evolved. Thereafter, the two more recent 19th and 20th century developments are the doctrine of legitimate expectation and promissory estoppel. Those are also a part of principles of natural justice and fair and equitable treatment. So, with the earlier, as I said, there were the discussions pertaining to scope of application of these principles. So, now these have expanded to administrative proceedings, and it is fairly settled. Now, there is no dispute whether the administrative proceedings are to be conducted in terms of the principles of natural justice and fair and equitable treatment to all the parties concerned in that process. So, now just a little bit fairness and arbitrariness. These are the two sworn enemies, and to obtain justice, to deliver justice, and to prevent miscarriage of justice is the basic aim. So, and there is a now new concept. The fairness is not only applicable to human dealings, but there is a growing requirement that we should deal with the nature also, animal kingdom also, in a fair manner. ESG guidelines are there. Section 166 of the Companies Act, trust. The principles of fairness and natural justice are generally applicable, but there is a slight limitation when it comes to equity. Equity can be applied when there is no specific provision of law. It cannot, if there is a provision of law, that has to be given effect to, whether it is equitable or not equitable. Only the constitutionality can be examined by the Constitutional Court. So, since the time is very short, so not going into the details of the principles, and we say that there is a paper in that it is mentioned. Now the question comes, whether, relevant question is whether apart from NCLT or Information Utility IBBI, whether COC, RP or liquidator, can they be considered as a statutory authority? Are they discharging public duties? If it is so, then they would be naturally binding to follow the principles of natural justice and give a fair and equal conduct fairly. If that is not the case, because generally what is happening, one point which I left out, that the principles of natural justice can be excluded by a specific provision or by necessary implication. If that is the situation, then the law has to prevail. And in the case of IBC, there are two situations where principles of natural justice have been violated. Particularly that no one can be a judge in his own case. In the present setup and structure, it is the financial creditors who are having a conflict of interest because of security interest and realization of their dues being the primary concern, which they could have otherwise in other laws also. So they are deciding all the things, and their decisions are non-justiciable also to a large extent. Commercial wisdom of COC has been made supreme. So that is one thing. And what is fair and equitable? Only there are two sections where the word equitable and fair and equitable have been used. One is section 3, subsection 6, which defines claim. So claim based on equitability, equitable claim is also admissible. And the other is the amendment which was a consequence of the decision of the Honorable Enclect in the case of SR Steel, explanation 1 to the section 30, subsection 2, clause B. We say that the distribution so made shall be fair and equitable. Though the word deemed in tax law generally, when a situation is assumed, the word shall be deemed to be fair and equitable, that is used. But in the case, to avoid any complication, the deem is implied, though they understand, the legislature understands, it is not a fair and equitable treatment. But still, they have given a shall be treated as fair and equitable, just to avoid litigation on that point and to overrule the decision of the Honorable Enclect. So that was the concept. So we have, when we see the BLRC reports, other reports and everything, and on ancestral guidelines, not only IBBI, but judicial authorities and particularly the Honorable Supreme Court have placed great reliance on those reports. So those reports are also say all the authorities are statutory authorities, they are discharged in public functions, code of conduct is there for resolution professional, and in August 2021, the IBBI put a discussion paper in public domain regarding conduct and for a code of conduct for COC. Unfortunately, regulation 71 capital A has also been incorporated in CIRP regulations, but no such guidelines has yet come, and the situation remains. And particularly, this situation has created a phenomena where there is no guideline and every action of COC is taken into the garb of exercise of commercial wisdom. That itself, by itself is very subjective. So these we have discussed, and now next one chapter is devoted in my paper on how this apply and what is the judicial approach for these things. So based upon that, principles of natural fair and equitable treatment are applicable to for the conducting the process under the code. But still there are divergent views. Let a final word. The Supreme Court in two cases, in Swiss Revens and in the case of Balal RCK and Siva Industries, have made explicit remarks, observations that in case of arbitrary, capricious or unreasonable exercise, the action of the COC can be examined and can be declared null and void. In the other chapter, I have given a tabular form, all the processes and section-wise, regulation-wise, where the fair and equitable treatment is implicit, explicit, and applied in all conduct of CIRP, liquidation, PPIRP, and other activities of IBC proceeding. Now there comes a question. In spite of making so many provisions, and in so many provisions fairness and equitable is being inbuilt, there are still gaps. And that is because time is short, so I have cut through most of the material and coming straight away how those gaps need to be filled in. I submitted this paper in December, and fortunately I find that 70-80% of the suggestions and gaps pointed out by me in the paper have been incorporated in the report discussion paper, which is on 18 January 2020 floated by IBBI. So most of the things
taken care of. I will skip those. But still there remains. And in Gujarat Urja Vikas Nigam, the Supreme Court has said that in the interim, when there is a gap in law, judicial intervention, having regard to the scope and purpose of the IBC structure, can intervene and harmonize and take care of the situation. So these gaps are mentioned at page 18. COC, because now comes the question of Swiss revenge. There are mainly two challenges on these aspects of fairness and equitable treatment. One was Swiss revenge and another was SR Steel. In Swiss revenge, the classification between the operational creditors and financial creditors, validity of section 12A, 29A, those were under challenge. Supreme Court, based upon the reasonable classification criteria, based upon Article 14, upheld the validity. But the observations and the assumptions which were made need a relook seriously, because while they were disposing of Swiss revenge case, they were provided some data. In that data, 80 cases were given, and that is mentioned in the order itself, where the operational creditors got roughly the same amount, or in some cases more amount, from the financial creditors. So in that background, they observed that there is no necessity to look into that it is being unreasonable. So now the next, and the assumptions they are mentioned in the paper, whether how far, and they went on the perception and the foreign jurisprudence and in legal jurisprudence of India in early 70s and 80s. Based upon that, they upheld the validity of the provisions of law. But when it comes to SR Steel, there was a challenge to word mandatorily used therein. In section 12,
They found it to be unreasonable, excessive, and prohibitive, and thus violative of Article 19(1)(g) to the Constitution of India, and they deleted that word. From the 330 days, mandatorily word is removed, it being unreasonable restriction. So now the question comes,
there is no single challenge to the IBC on the constitutional validity being violative of Article 14, Article 19(1)(g) and section Article 21, read with preamble to the Constitution, and Article 37 to 39A of Directive Principles of State Policy. Because in the Menka Gandhi case, the constitutional bench has said, even if it is reasonable classification, but it is impinging upon or violating any other right, fundamental right, then it can be declared unconstitutional. It can be elaborated since time is short. Now you can see. So what is the structure of IBC? Operational creditors get nothing, though it is being tried to be rectified. The preamble to IBC says, in a timely manner for maximization of value in a collective process for reorganization, to promote entrepreneurship and to make availability of credit. If suppose a creditor is not getting anything, how the credit can be made available? If I am an entrepreneur and I am supplying material to an entity which has become insolvent and my money is gone, how it will promote entrepreneurship? So there is even the scheme and the preamble, there is a total disconnect between the provisions and the structure. And in SR Steel in para 46, the Supreme Court has said the preamble is a guide and a limited jurisdiction of judicial review has been given to the adjudicating authority where those parameters have not been taken care of by COC, then these can be taken care of. Now just one point I would like to focus on is that in Shaira Banu case, Justice Nariman itself expanded and the scope of Article 14 from reasonability of the classification, now it is getting into the arena of arbitrariness, and there is another ground. If it is vague, some structure is vague, some section is vague, then also it can be declared unconstitutional. It is admitted fact that even the section 17, the discussion paper of IBPI says that there is no guideline which binds COC how to conduct. So there is no guideline, it's vague, and everything in that process is treated as a part of exercise of commercial wisdom of COC, which have got complete conflict of interest, and in fact the ILC report of 2018 also referred to that in the absence of empirical data, they were not making any changes, which now they propose to otherwise to give liquidation value to the secured creditors, and more than that to distribute amongst the operational creditors. So there is a paradigm shift, and most of the assumptions of the Supreme Court in Swiss limits, and they also accepted the one fact that we have to declare the constitutionality of a law based on general purpose, not on the absurdities and iniquities and crudities. So they acknowledge that it is crude. So, and one more fact last, that it is a proceeding in RAM. There is no part, even in section 230, bracket में subsection 6 of Companies Act, there is a consensus. There is a provision for approval by different class of creditors. Here there is no such requirement. So that's a very worst part. Even in all other jurisdictions, be it Chapter 11, whether it is UK, whether it is Singapore, everywhere the operational creditors have got a say. So at page 27, thereafter, I have noted down and pointed out the points on which the constitutional validity of IBC as a whole can be challenged. With these remarks, thank you very much.
Thank you so much, sir.
I just want to check with you. Any businessman or professional, when he enters any business or profession, he is aware of the risk factor. So, and when a business is going on, some bad debt is very much expected. I am talking from the perspective of the operational creditor. So, if that is the situation, and he has been, I have been a CEO or a financial manager also in my industrial experience. From that perspective, the normal action taken by that business needs to be that if the credit for 2 months or 3 months has not come back, he needs to stop his supply and take precautionary action. So in that perspective, do you think, I am giving a very contrarian view.
Yeah.
Do you think,
I will answer that.
Is there a need for to be, to have too much soft corner for the operational creditors, and the very prescriptive proposal which is made that the difference between the liquidation value and the realization value has to be shared with all, which is very contrary to the global experience.
No, it's not so. First of all, the operational creditors have got different rights. Even in that, I just narrated an Indian Companies Act also. If there is a scheme of arrangement of a class of creditors and secured creditors, they have to give their consent also. So it's not that it is in other jurisdictions. There are several measures by participation, by voting, and otherwise also by statute. Some protection is given. As far as you are saying that it is a normal business risk, I know that. There is no issue. But can the legislature forfeit your right to recovery without your participation? That is the question. If I am suffering because of my risk-taking ability or adventurism, I am at fault. So I will take necessary precaution. I will not deal with that. But to say if you see individual operational creditor or amount they lend to the businesses, it may be small as compared to financial creditors. Here, IBBI should carry out a study whether the overall operational credit is more than the financial credit in the system or not. So it is where the fairness and equity comes. If a person is weak, he needs to be protected. And the directive principles of Article 37 clearly says in making laws, the fundamental principles of governance will have to be followed, which with the basic preamble, justice, social and economic. I am not elaborating on Article 245 and 246 and 368, we will travel too far of the Constitution. But constitutionality of a preliminary legislation can be challenged.
Small rejoinder to what
Yes.
the members just said. He said operational creditor should stop supply if he thinks that it is risky. My contention is if a financial creditor has gone to the IBC and filed for bankruptcy, the operational creditor in fact thinks that he will get money from the person, but with no fault of his, he is first
Exactly.
of all trapped.
That is what the point is.
Yes, that is one. Second thing is, in the waterfall, this fellow comes at the last. If the operational creditor comes in the last, then there is no incentive
That
for
is why
paying
I have
business.
floated a question to IBPI, they should understand. And if you ask me one, I will end with that. One great success of IBC is unrecognized. That is realization of operational credit before admission, either by withdrawal or under Section 12A, after admission immediately. And the amount and the recovery rate could be more than 90%. So that is the only success which goes unsung. So because the recovery is not the aim of that. So we can have a multiple discussions. There are my view is very clear. My paper elucidated that. If we see the contradiction between preamble to the structure of IBC, as affirmed by preamble is a law, as in the SR Steel itself by the Supreme Court, and if you in the Menka Gandhi case, there was an interplay that has been established. All articles to fundamental rights 14, 19, 21 have got an interplay. Cannot be, if one is met, it doesn't mean that the others cannot be invoked. Thank you.
Thank you. Thank you for the wonderful presentation. So we'll move on to paper 3, which is the impact of section 29A on the CIRP, a detailed analysis. So for this, we have Ms. Akriti Gupta, a law graduate who is currently practicing at the Punjab and Haryana High Court in taxation and corporate law matters.
Good afternoon, everybody. So, as the screen says, the topic of our presentation is impact of Section 29A on the CIRP process and its stakeholders. So, for the purpose of our presentation, we'll be dealing with the introduction of Section 29A, how that story goes, the role of the stakeholders, and the way forward for 29A proper implementation.
Giving a brief background of 29A, as we are all aware that 29A was not something that was present at the inception of the code. The legislature, while has been given a wide power by the Constitution, still cannot predict what will happen after a law has been actually implemented. Thus, Section 29A was primarily introduced after the Synergy Duri automotive cases, wherein the related party of the corporate debtor was able to scoop up the corporate debtor again by giving 94% haircut to the financial creditors. Thus, there was a need felt, as it was also stated by the Honorable Finance Minister Sri Arun Jaitley, that it has to be ensured that unscrupulous people do not get benefited at the cost of creditors, and thus Section 29A was introduced. As the Section 29A was introduced, tremors were felt by all the stakeholders of the process. There was a sudden fall in Section 10 applications, and when Section 29A was introduced, it was applicable on all the corporate debtors without fail, and no relief was given. However, as it has been also discussed in the morning panel, certain exemptions were given to the MSMEs under section 248 subsequently. Coming to the impact of section 29A. Okay, so once section 29A was introduced, there was also a need felt for section 12A. Section 12A permits, after admission of the CIRP, to withdraw an application by the financial creditor. The promoters were in fact incentivized after the introduction of 29A to settle their dues with the creditors at various stages. Provision for withdrawal of application at pre-admission stage was possible, however, there was no provision for post-admission withdrawal of the application. This was also noted by the Supreme Court in the case of Uttara Foods and Feeds Private Limited, wherein it was said that even though the power is being exercised by the NCLT and the NCLAT to withdraw such applications, however, this power lies with the Supreme Court under Article 142, and thus there was multiple applications to the Apex Code as well. In this background, Section 12A was introduced with effect from 6th of June 2018. As per the IBDI report titled Leveraging Behavior Change, out of 3945 CIRPs concluded till the date 30th September 2022, 40% of the cases were concluded on account of withdrawal. Moreover, out of the said withdrawals, 53% of the cases has been withdrawn on account of full settlement with the applicant creditor. Thus, the fear of losing the corporate debtor altogether has nudged the promoters to settle the matter, leading to a major behavioral change. Coming to the second major impact is the increase in litigation by the promoters. As it was being discussed yesterday as well, there are multiple IAs in a single CIRP process, due to which the burden of the NCLT has also been increasing, and further of the NCLT and so on. In the judgment of Messrs. Jammu Powers, the trend of applying delay tactics by the promoters was also noted, because they are aware of the fact that because of the introduction of Section 29A, they no longer are able to attain the corporate debtor again at the end of the CIRP process. In fact, there has also been an impact upon the timeline of the resolution process, where the average period of CIRP leading resolution has increased to 561 days as against what is prescribed by the statute. Delay tactics by the management do delay the process, but also due diligence need to be conducted by the by the RP, which is an extensive exercise which not only leads to delay but also needs the RP to be trained in this area to attain this information. In fact, the attempt to backdoor entries by the promoters has also increased. The cost of CIRP has went up. The RP has to, in a number of cases, employ third parties to look into the due diligence part of it, and there are also litigation and incidental costs as well. The jurisdiction, not discussing the legal issues in much detail as we are all aware, I'll be coming to the role of the resolution professional that he has to play in the entire process. As the code was introduced, the mandate of the resolution applicant is there to file an affidavit that it is 29A compliant. However, this affidavit is not enough, of course, for the RP or the COC to decide that whether or not the person applying for the corporate debtor is actually 29A compliant or not. At the same time, duty is cast upon the resolution professional to do due diligence. This due diligence has to be conducted upon the basis of public information. And let me be very clear that public information is not so public these days. Even if some information can be searched upon, can be found upon by a simple Google search, it has to be seen whether the information is something that can be relied upon, whether the information is available only upon this website, or it has to be cross-checked. The duty and the role of the RP in regard to 29A was also discussed at length by the Supreme Court in Aerosol Mittal India Private Limited versus Satish Kumar. Additionally, COC2 has been empowered to examine 29A eligibility, but still the tools that are available with the RP are very less and are not, in fact, something that can be dealt with. In this regard, I have placed on the PPT as well the case of Mr. Sumat Gupta RP, Messrs. Vallabh Textile Company versus Messrs. Agrasen Spinners. In this case, the information about the ineligibility of the resolution applicant was received after the resolution plan had already been approved by the COC, and that information was not received from a public source but was received from a third party. In this case, thus the NCLT noted that it is the lack on part of the RP that he was not able to use the tools correctly. But to highlight the fact that not many tools are available with the RP at the very first place, there is definitely a need for the evaluation and further development of the information utilities as well to provide the RP with those tools through which a proper due diligence within time at less cost can be done by the RP. To quote a few examples, one of the disqualifications that is there under 29A is that the RA cannot be an undischarged insolvent. The data available with the resolution professional is based upon the affidavit that is submitted by the prospective RA. Now, the challenge is that there is no public information available whether or not this prospective RA is indeed an undischarged insolvent or not. Similarly, is the case with being a willful defaulter, as well as certain other disqualifications that are listed under 29A. Now, coming to the solutions part of it, what all steps can be taken to deal with the situation in a more effective and efficient manner so as to get the maximum outcome of 29A. The first and foremost suggestion that me and my co-author would like to make is that a jurisdiction has to be given to RP to pass a speaking order when it says that a person or resolution applicant is not 29A compliant. If a parallel can be drawn with taxation law as well, Section 148A under the Income Tax Act was introduced so as to lessen the burden of higher judiciary while dealing with cases of reassessment, so that the judiciary can leave the fact-finding mission upon the assessing officer and can give its decision only based upon the law. Therefore, similar power in this regard can be given to the RP or the COC as well, wherein a 2-page, 3-page or how much quantum of decision can be passed by the RP, and the NCLT can work upon that decision, build upon that decision rather than doing the fact-finding mission itself. Moreover, and alternatively, the NCLT can be given the power to decide upon certain disqualifications which can be subsequently cured as well. For example, in the case of Agrasen Spinners itself, the Supreme Court noted that even though the resolution applicant was not empowered, was not a compliant 29A resolution applicant at the beginning, but subsequently he removed his disqualification and therefore he was an eligible RA now. Such kind of jurisdiction can be given to the NCLT as well to decide whether or not this is a disqualification that can be removed and the corporate debtor can be sold off at a much better, much higher price that is provided by a subsequent 29A compliant resolution applicant. In addition, the jurisdiction to COC can also be given to exercise its commercial wisdom. We already have laws preventing anti-competitive agreements like bid rigging. This power that has been given to the CCI can be played along with IBC, and if there is a need that the bids that have been given during the bidding process, during the auction process, market forces can actually have a better role at deciding whether or not such information can be accepted, such proposal can be accepted. And if there is felt that there is some bid rigging, again the case can be referred to CCI. In fact, there can also be an increased scope of section exemption under Section 240A that has been extended to only MSMEs. It has been noted that some industries like real estate as well as service industry can also benefit from Section 240A exemptions. In certain cases, even reverse CIRP has been proposed, especially in relation to real estate. To be specific, in the Umang Real Tech Private Limited case. Further, the RPs need to be trained to properly and formally use the public information so that they can do this due diligence in a better manner. And last and but not the least, easy availability of data is something that we need to work upon still, so that a proper and more efficient due diligence can be carried out in relation to 29A, and maximum fruit from it can be taken away. Thank you. Yes.
Thank you for the presentation. We'll now move to the Q&A round. We'll have a couple of questions.
Is there any study or provision in IBC which prohibits the Section 29A person to come back after implementation of resolution plan? Is there any bar in time, or whether this is being abused by making a front entity as a resolution applicant, take the entity, the corporate debtor at negligible value, and thereafter come back after 2 years, 3 years? Is there any bar? Is there any check and balance?
To the best of my knowledge, sir, no, there is no bar. There is no check for the ineligible resolution
applicant to come up again. But that is where the CIRP process that has once concluded should be considered concluded.
That's there, but the object of 29A was not to allow the backdoor entry of the errant promoters, and that is happening in the other way.
That is true, sir. That is where the concept of market forces also come into picture. Considering the position of a COC, let's say I'm a COC member, the only even though we say in a very idealistic situation that recovery is not the aim of IBC, as a COC member, my only concern is for the recovery of maximum amount. As a COC member, I might in future want to deal with the fact that some RA is coming to me with much more price than at which I had sold it in the CIRP. As a COC member, I will consider it, but at the same time, if instead of 29A, market forces are allowed to play, the person making the bids, who is an ineligible RA, will be able to take away the company with a huge haircut. That has happened in the past. That is happening everywhere. That is right.
That is why the Honorable Finance Minister also said it's big game.
Yes, indeed.
We'll move on to the next.
Yeah, I mean, this is more an input rather than a question. I think there are cases where the avoidance applications are filed by RP and the resolution plan for approval, which is given by the respondents in the avoidance application, are also filed. Of course, there is one judgment by Katak bench in Madurga and NCLAT, which you may consider, but there may be other cases which have not come to the fore. Possibly some of the resolution plans would have got approved without the avoidance application of the promoter directors being adjudicated. This is an input for you for research. I have shared whatever I have observed.
Thank you, sir. Thank you.
Take the last question.
Good afternoon. I agree with you, with respect to 29A as resolution professionals, if you look at, there is a word that based on the document submitted, the RP has to scrutinize. So if the document is not submitted, then RP won't know about it. Third issue, yes, there is no common platform where this ineligibility of 29A, regarding the bankrupt or NPA more than 1 year, that information is not available. But this information is available with the financial creditors, most of the financial creditors. Maybe through RBI's intervention or something, one public document can be published on a periodical every 3 months or 6 months, which the RP can use to ensure that 29A is complied with. These are all some of the suggestions. Thank you. And also, with respect to avoidance application, when we file avoidance application, basically we have determined based on documentary evidence. But the adjudication is not happening for more than 3 years. I have so many avoidance applications pending. When that is the case, allowing that promoter to come into it through this, because adjudication, that is wrong and it's violating of section 29A. So that also needs to be addressed, I feel, in the law. Thank you very much.
I would definitely is that even though there is a provision that the documents
Applied
applied
by the RA are to be the basis of deciding whether or not the RA is 29A compliant. There are certain expectations that are joined to the role of RP. The COC is expecting the RP to conduct its own due diligence. The NCLT is also expecting the RP to conduct its own due diligence, and only after then a resolution applicant should be selected. In this situation, the RP becomes a little, I would say, na ghar ka na ghat ka kind of a person who has to look into it at his personal level as well, even though there is a provision of law to protect him in the sense that the documents that have been submitted by the RA are the only ones that are to be relied upon.
Thank you so much for the presentation.
No, we can proceed. We are only short of time.
So we'll move on to paper 4, which is the empirical analysis of early signals of financial distress using accounting, market and reporting anomaly variables. So the presentation will be done by Mr. Mohammad Suhail PS, who is a doctoral student in finance at the Department of Management Studies, IIT Madras. So, thank you.
Good afternoon, everyone. Welcome to my presentation. The title of the presentation is Empirical Analysis of Early Signals for Financial Distress Using Accounting, Market and Reporting Anomaly Variable. So this will be the structure for the presentation. First, I will start with the introduction and motivation for the study. So financial distress indicates a firm's inability to meet its financial obligation, and it comprises of 4 different terms: failure, default, insolvency and bankruptcy. This 4th term itself can be seen as a different phases of financial distress. Failure occurs when the firm fails to service the debt on time, and default can be either technical or legal based. Technical default occurs when the firm is unable to service the debt, and the legal default occurs when the firm violates the debt covenants. And insolvency is when the firm files insolvency proceedings in a particular country, and the bankruptcy is when the firm undergoes some kind of statutory procedure which may end up with a legal declaration that the firm is bankrupt. Financial distress does not necessarily imply that the firm will ultimately fail, but the constant deterioration in the financial performance may lead to bankruptcy. If you look at the consequence of financial distress can be enormous. In addition to the loss accruing to the shareholders and creditors, there can be disruptions in supply chain, reputational damage, and reduction in the remuneration and other social and welfare costs. In order to minimize these consequences and forewarn the bankruptcy prediction models were developed by considering various signals such as accounting, market, corporate governance, and macroeconomic signals. The studies that have used accounting variables to predict or explain financial distress it's based on the assumption that the financial statement reflects a fair view of the financial position. But that is not always the case, because recent studies shows that distressed firms have strong incentive to manipulate the financial reporting pattern to conceal the deteriorating condition of the firm. This we call it as reporting anomaly in our research. I'm going to the motivation for the study. This figure you can see the year-wise classification of insolvency and resolution process. So there is a rapid increase in CARP filing from 2016. So what happened in 2016? We know the Insolvency and Bankruptcy Board of India was instituted by replacing the BIFER, and IBBA has brought in stringent regulations regarding the insolvency regime in India, and this has resulted in more than 5,000 companies filed for corporate insolvency and resolution process, and this has resulted in around 46 out of the resolved cases. 46% of the cases are resolved through a liquidation plan, and 14% of the cases are adopting resolution plan. So the rapid filing of this insolvency and resolution process could indicate the presence of financial distress among Indian corporates. So this motivates us to study further. And having set the context, we started our literature review. When we started a literature review, the aim of the review was to identify the literature that deals with the various signals of financial distress, not various signals, only financial signals. And we followed a systematic literature review methodology. And as you can see here, this was the literature review framework that we have used. And finally, we came up with around 43 relevant articles for our study. Coming to the first part of the literature review, financial signals of financial distress. Bankruptcy prediction models were gained particular attention in 1930s with the seminal work of Fitzpatrick. Since then, accounting ratios pertaining to liquidity, efficiency, leverage has extensively been used. So we try to synthesize those evidence into these buckets, and we have also collected the impact of these signals on financial distress. As you can see here, the highest number of evidence is from the profitability category, followed by financing and leverage. The studies that purely used accounting-based signals were severely criticized by different authors, highlighting that the accounting numbers do not reflect the firm's future performance, and the ability of accounting information may be limited in predicting the bankruptcy. In light of these criticism, several authors came up with market-related signals. For example, Melton 1974 developed its first market-based default model by extending the option pricing theory model of Black and Scholes. And in 2001, in Schumpe, they used the discrete time hazard model to model the bankruptcy, and concluded that most of the variables used in the classic works of Altman and Swiderski were insignificant. Similar results were found in Chava and Jaro in 2008 also. There are studies that use the combination of accounting and market-driven variable, but as you can see there's still a lack of consensus on which group of signal explain the financial distress accurately. The second part of the literature review deals with reporting anomaly as a signal of financial distress. As I mentioned already, the studies that have used purely accounting variable assume that the financial statement reflects a fair view of the financial position. But there are studies showing that distressed firms have strong incentive to manipulate the financial reporting pattern. So we try to synthesize the evidence literature into these buckets. And as you can see, the empirical evidence is very limited and the results are mixed. One of the recent studies by Ashraf, he combined accounting, market, and reporting anomaly variable in the prediction model and found that the accuracy of the model is increased by using a combination of these. If you look at the Indian literature, the extant literature in India has more focused on the existing bankruptcy prediction model, and that too focused on the specific industries. And one strand of literature focused on the macroeconomic determinants. Even these studies restricted their data period prior to 2016 to avoid the impact of insolvency and the bankruptcy code. So the minimal empirical studies in Indian context again re-emphasize the need to understand the signals more better. And if you look at the reporting anomaly also, there are no studies that consider the reporting anomaly as a signal or antecedents in the distress model. So there is a lack of consensus in this area also. Having conducted the literature review, from the literature review we have formulated our research gap, objectives and hypotheses. So these are the research gaps. Despite the numerous development in the literature, there is a lack of consensus on which group of signals explain the distress better, and also studies largely fail to consider the incentive of a distressed firm to manipulate the reporting pattern, and studies have used arbitrary definition of financial distress, with very few studies considering the data from IBBI. From the research gap, we have formulated our objective. The objective of the study is to build a hybrid model that combine variables from accounting, market and reporting anomaly to identify the financial distress signals. So these are the rationale for our objective. As I mentioned, these are the gaps and how we are addressing those gaps in our study. We have using a combination of different signals, and we are considering a long time horizon, long time frame, unlike other studies, and to capture the effect of earning manipulation, we are using a proxy for reporting anomalies. And most of the studies in Indian context, they have an argument that the default forms under IBBA are in the early stages of legal proceedings. But if you look at the resolved cases, 75% of the resolved cases are either a part of BIFER or default. So the economic value was already eroded when it came to IBBA.
No, this is not clear.
Yeah.
What have you taken as proxy for reporting anomaly?
I'm coming, sir. I'm coming to that. So these are the specific questions that we have. What are the early signals of distress? How do signals vary under different definitions of distress? Which group of signal is superior in explaining the likelihood of distress? And what is the effect of reporting anomaly on the distress? And these are our theoretical support for the studies coming from signaling theory and positive accounting theory. And these are the two hypotheses that we are proposing. The combined model will have more accuracy and there will be a positive impact of reporting anomaly on distress. So coming to the data and methodology, the existing studies have used varied definitions of financial distress. They are mostly using a financial health-based definition. So in financial health-based definition, the firm year observation is considered as distressed when the firm year met a specific threshold of accounting or a market-related variable. But we are proposing a three broad-based definition, financial health-based, legal outcome-based, and a combination of these two. In financial health-based, a firm year observation is considered as distressed when EBITDA less than financial expense for 2 consecutive years, net worth to total debt less than 1, negative net worth for 2 consecutive years. In legal outcome-based definition, a firm is considered as distressed when it filed for insolvency through CARP under IBBI, and a combination of these two is considered as in third definition. The dependent variable for our study is a binary variable that taking a value of 1 for distressed and 0 for non-distressed firm. And coming to the sample description, all NSE listed firm and listed firm that have filed for insolvency under CARP is considered for the study. And we have excluded the financial firms, and the period of study is from 2008 to 2021, and the financial data of all companies collected from CMIE Progress IQ database, and the details of distress data is from the IBBA research division. And we have followed a panel logistic regression method for the data analysis. And this is the sample selection criteria under E3 definition, and by applying these three definitions, we got 3.3%, 15.4%, and 1% firm year observation as distressed. And coming to the variable selection, the explanatory variable for the model is selected based on the literature and within the purview of financial theories, broadly classified into accounting, market, and reporting anomaly. In accounting variable, all these variables are considered to capture the deteriorating condition of the firm. And coming to these are the variables that are included in the appendix also. Market-driven variable, we have taken market capitalization, book-to-market ratio, market value of equity to book value of debt, followed by Shumway in 2001. And unlike other studies, we have taken the variables from forensic accounting and creative accounting studies to capture the effect of reporting anomaly on financial distress. So we followed three essential characteristics of an earning management manipulator using Benesch and Serrano-Silca, and these were the variables: sales growth index, coefficient variation of sales, gross margin index, coefficient variation of profit, asset quality index, selling general administration index, leverage index, depreciation, daily sales receivable index, and total accrual to total assets. And coming to the findings and discussion, first I will talk about the descriptive statistics. Descriptive statistics are provided like this for the entire three definition. We have provided the results for distressed and non-distressed firms separately, and we also did a t-test to understand whether a significant difference exists between these two groups. And I'll go to the results part. Coming to the accounting and market-related variable, nearly all profitable variables exhibit negative values from the descriptive statistics if you look at the financial health-based definition. But in legal outcome-based definition, those firms that are only filed for insolvency, they have operating profit margin and return on equity are still positive, but lower value when compared to non-distressed firm. When come to the third definition, the firm that have filed for insolvency and also experience severe financial problem have negative value for all profitability variables. Coming to the finance and leverage signal, debt to assets and debt to equity ratios for distressed firm is far higher compared to non-distressed firm. So it indicates the presence of leverage, high leverage, and turnover ratios and cash flow ratios, like asset turnover ratio, cash return to total assets, operating cash to debt, and operating cash margin is less for a distressed firm when compared to non-distressed firm. And coming to the reporting anomaly variables, a lower sales growth index is recorded for distressed firm, which indicates substantial decline in sales and poor prospects, and higher value of coefficient variation of sales given the decline in sales can be suspicious, and a higher value of daily sales receivable index, that is improportionate. There is a improportionate balance between sales and the receivables, so which may be an indicator of inflating the revenue. From the descriptive statistics, we have constructed a earning management index by taking only those variables that have high discriminatory power using the methodology of Anderson and Serrano and Sinca. And coming to the empirical findings, so empirical findings are provided in the paper like this. These are the variable, and we have 3 panels. The first panel is financial health-based definition, panel B legal outcome-based, and panel C is a combination of these 2. And in each panel, 3 models are presented. The first model is purely accounting variables. In model 2, accounting and market is also appended. In model 3 is the hybrid model, where the combination of all 3. And accuracy measures are also given. So I'll go to the findings. If you look at accounting signals, nearly all profitability variables except return on equity is negatively associated with the financial distress, which indicates that the decline in the ability of assets to generate profit, decline in the profit from the core operation can lead to non-payment of debt and other expenditure, which in turn results in financial distress. If you look at the finance and leverage signal, in panel A, that is financial health-based definition, they have a significant positive relationship, which indicates that firm with excess leverage is at the risk of financial distress. But in panel C, that is the firms that file for insolvency and facing severe financial problems, it is insignificant. Maybe because they must have exhausted all their borrowing capacity, as the law restrict credit access to such firms. And negative association is reported for asset turnover ratio and financial distress. Surprisingly, cash flow variables is found to be less significant in this context, and this counterintuitive signs of cash flow variables may be due to the purposeful alteration of cash flow timing. And coming to the market-driven signals, as expected, all the market-related variables is negatively associated with the distress, which indicates that the market reflects the deteriorating condition of the firm, and market equity near the bankruptcy is typically discounted by the traders, and it also indicates the pessimism about the financial soundness and the poor future earning expectation. And when the reporting anomaly, that is a proxy for reporting anomaly, is the earning management index. So it's clearly shown inconsistent finding in both panels, panel A, B, and C. So in panel A, if you look at the increase in EMI is positively associated with the distress. So these firms are in the early stages of financial distress, so they are trying to engage in earning management to protect bonuses, reputation, and jobs. And these are listed firms. They are obligated to present high quality financial information. This is in line with the second hypothesis. And in the panel B, when the firm files for insolvency, they must have exhausted all the capacity for further manipulation. And in case of distress, third panel, that is, they are facing severe distress and insolvency, they will try to secure more cash flow rather than engage in earning management due to close monitoring from the regulators. So the overall results indicates that the combination of these 3 signals can enhances the model accuracy if you look at R square. And to conclude, despite numerous developments in the literature, an empirical examination of various signals of financial distress in India is scarce, primarily due to the use of existing bankruptcy prediction model restricted to a specific industry, use of varied definitions of financial distress. So the overall result shows that the return on assets, asset turnover ratio, debt equity ratios are the significant predictors. Surprisingly, cash flow information is observed to be less significant, and the inconsistent evidence of earning management index indicate that the choice of earning management is primarily depends on the distress continuum, and the inconsistent evidence of different signals across 3 definitions indicates that the signals can vary different signals can vary differently according to the degree of distress. Yeah, thank you. These are the key references. I'll start from now.
Very nice presentation, Sohail.
Yeah, thank you.
Just two small queries. First is that in the identification of distress as per legal, you mentioned that if it is filing under CIRP of the IBC, it is identified as financial distress, right? So your sample is basically from 2009 or 11?
For the
2008, right? So before IBC, how did you identify on the basis of legal framework?
Yeah, sure. So in panel B, we have only considered the data from 2016 to 2021.
Okay.
The latest figures only we have considered.
Okay. And my second question is, in the table that you have shown results for model 1, 2 and 3, my only apprehension is that since you are using many indicators that are very similar to each other like ROA, ROE and other measures of financial distress, I see potential correlation among the variables.
We did the potential. It's there in the appendix.
Okay.
We did a collinearity check also. We have removed one or two variables only. So we did the multi-collinearity check actually.
Okay.
So
So the VIF and all other things, I believe you might have already done. So just that was the only thing. Thank you.
Could we find an explanation why the cash flow variables seem logically to be important, but not found to be that significantly correlated?
Yeah, it is significant only in one panel. When we define distress based on some financial health parameters, it's significant. But in other panels, like when the firm distress is defined based on the filing of insolvency, and the third panel, it is found as insignificant. So
the correct question should have been whether in those cases where the firms were ultimately came for filed for bankruptcy, were your cash flow predictions would have predicted these cases early.
yeah,
So I'm just giving guidance for future research.
sure.
Because that would have been a very, very relevant question.
Sure.
Because when they come for insolvency, at that point of time they have exhausted everything, as you have rightly pointed out. But can cash flow variables predict early whether this firm is going to be better? So taking these cases and find out 3 years and before data and find out whether cash flow variables can predict that kind of.
Got it. Yeah. Sure, sir. We will include it.
We'll take one last question and rest we can take off.
I ask a very small question. How did you combine the panel A and the panel B for panel C? Because you said C is, sorry, not panel A and panel B. How did you combine the legal and the financial? What was the weightage? What was the formula?
Panel A, firm year observation is considered as distress when it met those 3 criteria. In panel B, is recorded as 1 or 0 if the firm files for CARP.
Okay.
So these 2 conditions met, it will take as 1 in the third panel.
I feel like because there are other frameworks to decide financial distress legally also, I feel like when filing of insolvency might be too late.
Yeah, actually
we would like to consider the RBI's prudential framework norms where you have special mention accounts, because that's probably when the first sign of distress comes. And it might be too late.
Yeah.
The filing of insolvency might be too late.
Yeah, sure. Thank you for the input.
You have given the parameters on which you can identify the distress, the accounting, legal and everything. But from the business perspective, this study doesn't show any parameter of what are the causes of that distress, whether it is a case of business failure or financial failure. That needs to be addressed, and how it can be addressed before they reach to the point of insolvency. So that is study, if that is there, otherwise there could be a cases of initial gold plating, there which is not covered there, the project may not be viable or it is gold plated, highly leveraged because of other intentions. So the empirical study must look at the causes of default and provide the solutions.
This is not his study. It can be several studies, but that is not
Thank you.
Thank you, Suhail. We'll begin with our last presentation of the day. So the title is Resolution Applicants are Stakeholders in the Successful Resolution of Corporate Debtors. And so,
Thank you. Am I audible? And for the online, this is fine?
sorry, just
Pull it up.
can you keep this?
To getting their throats choked, sir. This is quite dramatic. So good afternoon, respected chairs, Honorable Justice Srivastava sir. Good afternoon, sir. Senior members of the IBBI, respected seniors, my friends and colleagues, ladies and gentlemen. I am Vijay Iyer. I'm a resolution professional. I am joined by my colleague, Mr. Asman Joshi. Unfortunately, my other colleague, Ankur Bhargava, is not here. And we are here to present actually a positive side of the IBC story. We hear a lot of negativity, the challenges RP faces, challenges of information, challenges of creditors. We thought, let's look at successful resolutions and the role of successful resolution applicants. Who are these champions who actually play that role of success? Where do they come from? Which industries are there? Because we have over 500 cases of success of the IBC. Realization better as compared to other industries? Is the realizations dominated in any particular industry? And what are some of the challenges these resolution applicants are facing? And could we make their life a little better? After all, they are the ones enabling us to achieve that successful outcome. So the focus is on successful resolution applicants. So the question was, where are these successful resolutions coming from which industry? Do they belong to the same industry? Is the realizations better based on certain resolution applicants? Unfortunately, we are not able to see successful resolutions post the completion and post the handover of the corporate debtor to the successful resolution applicants. Has there been an actual turnaround? The case studies, there are a few, but they are very specific, and the data in the public arena is limited. And therefore, the other proxy is the level of realization through the resolution plans. Some of the challenges, and what could we do? What are the enablers, tools that we could make this even better? The data analysis was actually on the 517 cases which were successfully resolved. Of that, we were able to find data on 478 cases, the actual NCLT orders. But overall, if you look at the corporate data, the data of the corporate data is quite detailed analysis has been done by IBBI on a regular basis. We do see there's a dominance of the manufacturing sector there. Over 50% of the corporate debtors which have been successfully resolved are from the manufacturing sector. But when we look at successful resolution applicants, we actually looked at the orders, tried to find which industry they came from. We again find that it is the manufacturing sector where there is a dominance of successful resolution applicants. Obviously, there is a bias in the data when you do find that the corporate data itself, the number of cases in the manufacturing sector is that high. Obviously, the data to some extent would be colored by that. But an interesting outcome of this is that we find individuals, that is promoters, management, and other individuals. In the NCLT orders, you actually find that the successful resolution applicant is a person or a number of people. That will be very interesting, because if you look at that, over 80, around 82 plus 42, 124 resolution applicants are either the promoter, management employees, or individuals. A learned economist yesterday talked us about one hand, the other hand, right? On one hand, it's an interesting analysis. You have resolution applicants as individuals who will come forth, not to a specific industry. On the other hand, as also Sir said, are these proxies? And that could be requirement of further analysis by somebody else. But if you take the right side, like I said, the context of this is cautious optimism as far as this study was concerned. If there are individuals, then obviously this requires some degree of support. What is it that individuals as successful resolution applicants require for the support from the system to enable them to be that much more successful? If I look at it particularly from the corporate debtor side, if I look at the industry-wise analysis, Why is it that it shows allow? Sorry, there. It's come back. It's come back, it's come back. Something else has come back. It was here, sir. Yeah, but I think that's the Zoom one. There is a commonality of the corporate data and the resolution applicants. 70% of the resolution applicants of the manufacturing sector actually provided plans for the manufacturing sector. There is some commonality in the construction sector, 44% there. Thereafter, it does reduce. Financial creditors, it's an obvious answer that they do tend to connect with other industries or supporting resolution applicants along with them from other industries to make this work. Again, they are provided in 44% of the cases. Obviously, they don't do this on their own. Like I said, the interesting analysis was the role of individuals, promoters, obviously, which are Section 29A compliant, that they do provide support, maybe even homeowners associations or association of persons. And then in case of MSMEs, we did find that there is support in the system, as even Sir was saying, that if the person is not, is Section 29A eligible, we did find that plans do get approved. There is support of the system for MSMEs where we believe that there is hope for resolution and there is a degree of higher flexibility. Obviously, they're requiring it, as we realized today morning. And if you look at that one basic crude parameter of success as realizations, it was found that individuals did provide a significant percentage of recovery as compared to others as well. Promoters, management did provide the highest amount of recovery, arguably saying that they know the corporate data the best. Manufacturing sector, as per resolution applicants, did provide the next highest level of recovery, followed then by other individuals who are not defined as promoters. The analysis of who these individuals are, of course, there is not that level of, shall I say, valid public data. Then we'll have to go back to Google and find out who these individuals are. Are they a front, or are they actually high net worth individuals who have escaped the public scrutiny so far? There are 82 of them. So those are, as far as realization is concerned, ladies and gentlemen. And again, if you take it from the operational creditors, yes, sir, yes, manufacturing sector did provide a degree of support, but yes, I am sad to say that as when the other resolution applicants come, the degree of fairness and equity as far as operational creditors are concerned, there is a diminishing level. Then we come to what is it of resolution applicants. Resolution applicants may not talk to us directly, so a good conduit is through the resolution professionals. And resolution professionals who we talked to, we were able to talk to, we reached out to over 1,000 people. Finally, 50 talked to us, and they have in all covered over 160 resolution cases on their own. What was their input? Then yes, this is something which is pretty obvious, but the 7 points as to why this causes that, what are the impact of the delay? That is a good revelation, that yes, the delay does cause further distress. It does impact the successful resolution of a corporate debtor. But if you look at those 7 impacts, it does increase the CRP costs, yes. There is a lack of interest of the COC, which is right. Once this plan is approved, and it is stuck at NCLT, the COC also then leaves it as though this is for the RP to take care. There is some debate on the number of times an RP can call a COC meeting once the plan is approved. Keep that interest alive. Look and debate with the COC on how do we push the NCLT to get that plan heard. Are there any other supporting measures? But there is, and it's actually at this time, which I will arguably say, that the interest of COC is required, and I'll come to as why. Then there is a lack of funds. There is deterioration in the value, which again impacts the resolution plan by itself. There are changes in the business condition. And of course, the most critical is that it impacts the flow of cash which the resolution applicant has budgeted for. And he doesn't know when he's actually going to pay out. And his EMD is stuck till such time that the NCLT approves the plan. So it does cause a bit of frustration, and it does cause that degree of lack of support for a successful resolution. So I'm sorry. It's not the NCLT's fault.
Let me clarify. This phrase stuck in NCLT also responsible for that to a great extent. The RP disallows many claims because they are time barred or they are not substantiated by records, etc. So all those applicants, they come before us. In principal bench in Delhi, we are stuck with a plethora of interlocutory applications. There are as many as 100 interlocutory applications in one single case. I'm talking about real estate cases. We are facing a lot of real estate cases. Just now only, last Tuesday we pronounced an order after clearing around 75 interlocutory applications, and remaining 25 we said they are not germane to the plan. We will take care of them in due course of time. So that is the kind of problem which is before us, and I would request the RPs also to please help us.
Agreed, sir. Totally. And I know I should not challenge or defend, sir, but if you will permit me that in this indiscretion in front of you, sir.
Because you have to understand one thing. What can an NCLT do? It has to sit in court regularly. It has to apply its mind. It has to listen to the parties. It has to sit till late in the evening. And it has to work overtime even on Saturdays, Sundays. All that we are doing.
Yes. No, sir. In all my interaction with the NCLT, it's been a fantastic learning for me. Fantastic. The kind of effort and drive all the judges put is amazing. And I'll tell you this. I know for a fact, innately, every judge knows who's the crook in that room before the case is even heard. And as soon as the case is heard, you all know. Many a judge has told me, Vijay, I have to go through the motions, but I know who's the crook. I'm sorry, sir. But I'm so sorry. I'm so sorry. Yes, therefore, there are, unfortunately, the Supreme Court has also said that there are challenges and there is a reluctance, therefore, within the system as well, to enable a successful resolution applicant to thereafter withdraw a plan. But why? Why is a withdrawal of plan critical? And I'll come to that when we come to the conclusion. So there is, therefore, a cause of concern that resolution plan cannot be withdrawn. We did see the 7 reasons why it does impact the successful resolution and the sustainable resolution of the corporate debtor post their approval. But therefore, what should be done? Withdrawal is not an issue. Then, okay, if withdrawal is not so much an issue, can we look at better marketing, better analysis, better presentation to the wider world, where the benefits of the corporate debtor, the success, the synergies, as recently the district committee said, that one has to look at synergies as well, to offer corporate debtor, needs to be highlighted, needs to be echoed out better so that we have more potential resolution applicants. Apart from the public notice, apart from COCs being encouraged to approach resolution applicants, is there, the resolution professionals, obviously based on inputs from potential resolution applicants, have said, is there a specific portal IBBI could perhaps identify, or within the IBBI website, is there a particular place where information about cases in resolution could just be there? And what could be there? The Form G, the expression of interest, details of the corporate debtor, like basic facts, some of the teasers or marketing material which the resolution profession may want to put out, keeping, of course, the proprietary of information, the confidentiality of information, so that to encourage and envisage more interest. Is there a particular site so that resolution applicants, they say, I missed that public notice. Where do I find all these public notices? Where can I find more information about corporate debtors which are ready or which are available for resolution? And if there are 82 individuals out there who have provided successful resolutions, maybe there are many more. And therefore, these are some of the challenges. And the challenges, of course, we see. There is, of course, now, we found that the Reliance Infra case where we did find a solution for the first one. There is, of course, ongoing litigation where Sir himself has asked resolution professionals to be a little more careful. There are, of course, financial creditors, after the plan is approved, still harass in terms of, removing the corporate debtor from the list of willful defaulters. All those systemic, or shall I say, some process, some code box obviously will be loosened as people are made more aware, people see the benefits of IBC, people see more resolutions. I'm sure more and more authorities would support this. A bit of nudge, a bit of, shall I say, a poke from the elbow, from one regulatory agency to the other, and I'm sure all of us would work far better together. And ladies and gentlemen, therefore, conscious of time, I'll immediately go to the conclusions. One is on the delay. Yes, can we look at, if there is a delay, that maybe one day in the week, and in front of Sir, I'm that much more scared, and that much more wary of suggesting anything on what the NCLT benches should be doing. If they're not, as I was taught, Lady Vijay, if you work 24/7 and that's not enough, please start working weekends. I don't know what that meant, but therefore NCLT perhaps, and I'm not going to skip this slide. But on this one, this is the important one. Ladies and gentlemen, why? What are the other challenges? Suppose there is negligence by the RP and the Committee of Creditors, and that causes impact on the corporate data. We find, for example, environment clearances are not renewed. Does that not impact the resolution applicant? It does. Can you then force him to say that you have to take over the corporate data? Suppose those are those challenges. Suppose the corporate, it is still in the custody of the Committee of Creditors and RP, and we did find that the level of interest of COC diminishes once the plan is approved. But suppose something happens, then what happens? Then can you still force a resolution applicant to buy it? Suppose there's a change in law, change of facts. In this situation, if the resolution applicant, with the dominant approval of the Committee of Creditors, believe there is a sound case for this no longer to be feasible, viable, the point in law is the plan is no longer viable and feasible. Can you still force a resolution applicant to say, no, you have to still go ahead with implementation, since it's an approved plan? That is an issue which requires further debate. It is necessary for a degree of some leeway, some door, some window to allow that withdrawal in those extreme cases. And yes, marketing of the corporate data does enable better. There's one more, and we found this to be very interesting, a very good suggestion by somebody, that once you have the list of PRAs, allow a flexibility for more PRAs to come. Why? Because when I see my competitor in the industry, suddenly his name there, they say, "Hurry up, why? If he's doing it, why am I not?" And then there will be various reasons. Can I now come in? Can I join? Is there a 15-day flexibility possible? We still have time, right, before the plan comes through, because we have 165 days. So if 105 days, can we add that 15 days saying, once you see your competitor's name there on the PRA, would you also like to join? So that we have more PRAs joining as well. Because when we do find people coming back with excuses saying, I didn't see the public notice, I didn't see that, or it went to Gmail in my trash account, various excuses. So maybe this specific corporate website where the IBBI has, which again, continuously launches all this information about corporate debtors in resolution, wanting plans, wanting expression of interest, and this issue of marketing. And finally, therefore, the 4 key takeaways: yes, let us reward, let us regard, let us respect and appreciate the success of resolution applicants who have made the success of IBC. I commend the IBBI, and it's not just me, but the survey responses of all the steps, because every other regulation is either to improve the integrity of the process or to improve the outcome of the entire process. There is a necessity of looking at possibility of withdrawal of the application or withdrawal of the resolution plan in those circumstances. And yes, marketing the corporate data will help in getting more successful resolution applicants. Ladies and gentlemen, thank you for your patient hearing. Thank you. Thank you. So, we'll take a couple of questions. If you'll notice, ladies and gentlemen, I brought us back in time, sir. Yes, sir. That the issue of employee and gratuity, the Provident Fund and gratuity dues, there is now further guidance from NCLAT and Supreme Court on the matter as well, and I think that now even resolution applicants have realized that this needs to be addressed. But yes, in those cases where approval has already happened and all this has happened, that's done and dusted. Those which are work in progress, it does impact. It does impact.
Controlling, COC has lost interest. The unit assets, valuation, going concern status, and more so particularly the CIRP cost, which has a burden on a successful resolution applicant. So in this period, there must be some arrangement or some regulation where the successful resolution applicant can be involved into the running or otherwise taking policy decisions, so that that will also meet his the one of the objective to more active position. Otherwise, his funds are blocked. He cannot invest anywhere else.
Very good point, sir.
By apex, the Supreme Court has said he cannot.
Correct. What we do, sir, the smarter resolution applicants put it in the resolution plan, but till such time that the plan is approved by the NCLT, they will be allowed to participate in every COC meeting. The smarter ones. And even as good governance, what we do is.
The depletion in the value of assets, and the moment CIRP cost is the CIRP cost start valuing. There is also some variations in CIRP costs also. So to protect the people, ultimately these are all for the successful resolution. So there must be some. And one more thing, as far as the withdrawal is concerned, in my presentation I have written that that is a violation of Article 19. You can't prevent anybody to withdraw under circumstances. In fact, this is a known. You highlighted very well the importance of the SRAs and the concerns faced by them.
Thank you, sir.
Solutions we have suggested, let us see how we can take it forward. Thank you so much.
Obliged, sir. Thank you.
But don't forget 2 years of COVID. Even already the Supreme Court has granted
Yes,
remission
yes,
from that period.
yes, sir. Yes. That flexibility from NCLT is amazing, sir. Amazing.
So, I would like to thank the session chairs also, Shri Sandeep Garg and Professor Ashok. So, finally, I would like to invite Vinay Pandey, who is the manager at IBM, to continue the session.
Thank you. Okay.
This ends these sessions where we have lunch yesterday and dinner also. That is the MDC goods. I will request all the presenters who have not submitted their claim forms may kindly submit their claim forms for the reimbursement. As well as kindly submit the consent form if you are interested to publish your paper in our magazine. Kindly do that. Thank you. And also the most important thing, please make your presence here by 2:25 so that we can start the second session, the third session of the day on time at 2:30. Thank you.
Under IBC, perspectives and way forward by Mr. Bahram Vakil. Welcome, sir. He is the founding partner at AZB and Partners. Okay, let's start.
Thanks. Thank you, everyone. I know we are in the most difficult part of the day, post lunch and especially gulab jamuns. So thank you for a wonderful lunch. I just wanted to highlight two things. One is the presenter Saloni, and then we'll try and answer the questions that you have, the three of us who are also from AZB. And second thing I just wanted to make very clear is that, there's a lot of discussion on the waterfall mechanism and particularly on the government dues part. So being privileged to be part of the BLRC, just for everyone in this room, and you can share it as widely, of course some of us know that, but this was fully thought through by the government at the time when the drafting of IBC was done in 15, 16, whenever it was done. So this is not an oversight or a mistake. Right at FM level we had full discussion, then it was taken, it's even discussed in Parliament naturally. So it was done thoughtfully and for good reason. One is certainty for the financial creditors, especially the banks, and the less they earn and more uncertainty, the cost of credit goes up. So those arguments found favor at that time. Of course, we are in a super dynamic world, so today's situation is different. NPAs then were close to 12, today they are at 5.5. Hopefully we get some credit for it through the IBC and its practitioners. I can understand if it's evolving and we need to tweak. With that, Saloni, please.
I was just going to say, I think this is the best part of the afternoon. Just in terms of the flow of the presentation, we're just going to touch very briefly on the history, your 1956 Companies Act. Is this better?
No. What about this?
I can use this one also. Presentation. We're going to touch very briefly on the history. We're going to look at the position in the UK, what Unsitral recommended, what the BLRC thought through, which Behram's already touched upon, what the IBC provides, how courts have interpreted it, all leading up to the decision of the Supreme Court in Rainbow Papers, impact of Rainbow Papers, and way forward. I think most practitioners, at least most lawyers, will be aware that we've followed the IBC waterfall for liquidation as well as for CIRP from the UK laws largely. The UK laws themselves had some change in law. I think the position in the early 1900s was slightly different. It finally got revised to the waterfall that we follow in IBC in 2002, which is what we followed in IBC. Very briefly, the waterfall that we have for liquidation is first process costs, CRP cost, liquidation process costs. Then you have workman dues for 24 months, pari passu with secured creditors dues. Then you have employees dues for 12 months. Then you have unsecured financial creditors. And then you have ground debts. This is the current waterfall that we have under the IBC. For liquidation, which is also referenced in the distribution that we have for CIRP distribution. This follows largely, as I said, the position that we have in the UK, as well as the Unsitral recommendation. Unsitral had recommended that you don't give ground debts priority because it will lead to uncertainty as far as the secured creditors and unsecured creditors' position is concerned. It will lead to delays. It could potentially lead to delays. So Unsitral was very unequivocal in their recommendation that ground debts should not have priority. This was heeded to by the BLRC, and similarly BLRC was also very unequivocal in their report when they said that we don't think ground debts should have priority. They had 4 or 5 reasons that they mentioned. The key reason, as Behram mentioned, was it would create a lot of uncertainty for creditors. It would create uncertainty for outside IBC enforcement also. This would result in the cost of credit going high, which would impact the borrowers poorly. So the BLRC was very unequivocal that ground debts should not have priority, which is why we see the waterfall that we have in IBC right now in section 53. What has happened since then is that we've had several judicial pronouncements dealing with whether ground debt is operational debt, what should the priority be, how should the different state laws be interpreted qua IBC. And the position that has emerged leading up to Rainbow Papers, and I'll come to Rainbow Papers in a bit, but the position that has emerged before Rainbow Papers has largely been good. So first, in Synergies Today, the NCLAT said very clearly crown debts are operational debts. Crown debts are debts which are generally owed for the operation of the company as a going concern. Therefore, these are operational debts. This position was also followed in, I think, another NCLAT case. In Union of India versus Vijay Kumar Iyer, again, the NCLAT has said that DOT dues, which were license dues owed to the Department of Telecommunications, were operational debt. They had to be dealt with in the manner provided for in the IBC. Same position was held by, I think, the Rajasthan High Court in the Ultratech case. Again, the Rajasthan High Court said, crown debts, operational debt, please follow the waterfall in IBC. Rajasthan High Court also said that a resolution plan, once it is approved, is binding on all stakeholders, including government. So the government, it is not open to the government to wake up after a resolution plan has been approved and then challenge the distribution simply because it is being treated as an operational creditor. There are three other judgments which are important. We had Leo Edibles and Facts, which held that when there is an inconsistency between the Income Tax Act and the IBC, and when you're determining how recoveries have to be made for dues under the Income Tax Act, you look at the waterfall under the IBC. So this was the Telangana High Court. Telangana High Court very clearly said that dues can be calculated as per the Income Tax Act, but they will be recovered as per the waterfall in the IBC. And the same ratio was followed even in ABG Shipyard, where the enclave, where the Supreme Court rather said that the IBC will override the Customs Act as far as the waterfall is concerned. But in this case, it was dealing with the question of unsecured government dues, and therefore it did touch upon the question in Rainbow Papers. Now, coming very quickly to the case, to the case that we're presenting on, that we're focusing on. Here, you had the Gujarat Act, Gujarat State Tax Act, which essentially provided that the state tax authority would have a charge over the assets of a dealer to the extent of any tax dues, penalties, any other tax levies that the tax authority would be entitled to collect from the dealer. So dealer has liability to tax authority has a deemed first charge over the assets of the dealer. And the Gujarat Act also said that this would be notwithstanding any other law for the time being in force. NCLAT and NCLAT both ruled against the tax authority. This case then went to the Supreme Court. The Supreme Court interpreted this section to constitute a charge. And then the Supreme Court said that therefore, because this is a valid charge, the charge holder, which is the tax authority, becomes a secured creditor. And it then is entitled to be treated pari passu with any other secured creditor, which so far would have only been your financial secured creditors, your public sector banks, your bond holders, those who have a validly registered security. So suddenly we have the Supreme Court saying that a deemed provision under the law which does not necessitate any consent from a counterparty or an individual, but deems the existence of a charge is the same as a transactional charge. The reasons why this decision is a little controversial is three things. One is you have the Companies Act, which very clearly says that a liquidator or an RP, when dealing with the verification of a charge, must necessarily check that a charge is validly registered with the ROC. Obviously, in the case of state dues, there is no contract or transaction that is entered into by an individual, so there is no charge form filing with the ROC. You have the liquidation rules also, which similarly provide that when a liquidator is verifying the existence of security, the liquidator is going to check three things. Is the security registered with the IE? Is the security registered with the ROC? Is the security registered with SERSI? All three answers, in this case, in the case of any statutory dues having deemed security, the answers will be no. There is no charge form filing that you make in such a case. Commercially, I don't need to go into how this will impact lenders' credit analysis, because so far, at least as far as what we are aware, creditors don't account for non-transactional security as security when they're conducting the credit analysis. So the ramifications of this decision on credit analysis, especially if you think about, debtors who have government contracts, spectrum licenses, the ramifications for credit to these type of creditors would be immeasurable, so to speak.
And not only in terms of resolution of distressed companies, but also
lending.
New lending to these companies.
The cost of credit for lending to an RCOM right now, keeping in mind that it has 30,000 crore spectrum dues, would be much more than the cost of lending that was actually incurred by RCOM when they took their rules. The other legal concern with this interpretation is that the IBC defines security interest as interest, title, security which is created pursuant to a transaction. And a transaction is in turn interpreted as a contract or an agreement or an action by a party. In clauses that we're dealing
because there is no transaction, there's no contract, there's no agreement by a corporate debtor. So legally and commercially, this decision was leading us to an unviable, awkward, and not necessarily the correct interpretation. We had proposed 2 recommendations on how this should be dealt with, but I won't go into those because thankfully this issue has now been dealt with in the MCA's paper, when the MCA is dealing with proposed changes to the IBC. And what the MCA is proposing is that Crown debts, when they have security pursuant to a transaction, which is security pursuant to an agreement, an arrangement which is validly registered, this type of Crown debt can be considered as secured debt. For all other types of Crown debts, when there is only deeming language in the statute, that should not be considered as secured debt, and that will be considered as unsecured operational debt. With this, we conclude our presentation and open the floor to any questions.
No, just one last thing I wanted to say very quickly, especially for both of you, is that there is no question, I mean, you all are the much bigger experts on this, but there is no question if this change was not made, so thank God IBBI and MCA got together and were suggesting this amendment, the interest cost would go up, the rate would go up. And don't forget, just now we may be in a slightly benign interest, but it's going to keep going, because I presume the Fed is going to keep going, and therefore then it will really bite. And don't forget, the government is also a very substantial borrower, so when interest rates go up across the yield curve, it goes to the government as well. So on one hand, I think these were all the issues that were taken up by government at that time. Thanks a lot.
Thank you so much. I'll give it back. I just wanted to share the ramifications of this change would be much wider and consequential, not just limited to the IBC, although of course I know that in this room we're concerned more with the IBC. Because in 2011, it is in 2011 that a conscious decision was taken for the first time to bring the priority of corporate debt, the Crown debt, lower. And that happened pursuant to a committee that the Ministry of Finance had constituted, which Mr. Umarji chaired. That committee had recommended, because that committee was proposing the framework for the priority rules under the CERSAI, because CERSAI was being set up at that point in time. So this committee was formed to assist in preparing the framework for CERSAI registry. The recommendations of the committee were accepted, and that is why 3 amendments were made by the Parliament. One in the Insolvency Act, while providing the rules for CERSAI in the priority rules, where the framing of the charge, for the first time, it was in the country introduced that the priorities would be determined by date and time of filing. So public notice concept was introduced for the first time, and we will be distorting that completely. And this is based on the model of secure transactions, which unsecured, The second change that was made was in the Recovery of Debt Act also, where the priorities were changed and the Crown debt was brought down. And the third was also in the Insolvency Act, also in terms of how the proceeds of the sale will be distributed. These were the 3 significant changes that were made by the Parliament in 2011. And for us also it's a bit of a setback, because I was a member of that committee. I wrote that report. We made presentations to the Parliamentary Committee, and all that is a huge, it will be a huge setback, not just at the IBC level, but the entire framework of how secured transactions framework are done, the discipline in the whole credit lending system, where parties have a certain legitimate expectations on how their debt will be treated in the event there is an insolvency. So we are actually distorting the very fabric of the secure transaction system. It's not just bringing certain people up in the row, but it's also dealing with the entire fabric of secure transaction system, how it operates in the market, in the lending market. Is the point that I'm
That's very cool. Very good. Questions?
So yeah, I would like to, first of all, I would like to say that I can assure you that I'm not a bigger expert on this because I'm a finance professor and I've not really sort of looked at this in any sort of close detail. But if I sort of understood the presentation correctly, the base logic for why the court is arguing that crown debts are not, to be placed above other debts is because they're operational debts, right? Could it be the case that some crown debts are operational debts? So for example, if a telecom company gets fined by the telecom authority, that you can call an operational debt. But if the same company gets fined by SEBI, right, for some, some sort of, misdoings while they were raising funds in the stock market, would that also sort of follow the same logic of being an operational debt? That's what I was wondering.
Yeah. Go ahead.
The definition is very broad in the IBC for operational debt, and it would include that and penalties, but all used to come.
So if I may answer to your question, I think the penalties imposed by any authority, including SEBI, will fall in the definition of the operational debt. And that will also again not be a secured debt. So that is how the fabric of the code is made, and that is how this judgment is disturbing the entire fabric, as the two experts have expressed. And I have no question, in fact just my doubt whether in your paper you are suggesting amendment to section 3. If the 3 I think is very clear, it is defining the transactions in a very clear and very lucid manner, that it is arising the security interest arising out of any contract or transaction between the parties. So I think that itself is very much clear about the nature of the secured debt. Still the Supreme Court has felt it like that, but if I may share in this room that the Supreme Court is reconsidering the judgment, let us hope that the correct position will come out, and the amendment will of course take care of that if that happens. Thank you.
I have a question. How frequently is the Crown expected to update any registry regarding use from an individual or a corporate? And where is the registry and who updates on a regular basis?
You mean the records of each relevant governmental authority, right? I think those will depend on the individual rules that govern each
So it has to
authority.
be registered somewhere. Lodge a claim. See, for the if you want that a financial breakdown, we lodge a claim with NCLT.
Because the lenders will do a CERSAI, the company will do it RSI.
So your question, where can the government register? They have the IU register.
They have the
Information.
they registered over there.
Yes.
How promptly?
As soon as they want.
As soon as?
Immediately.
No, as soon as the default occurs.
No, sir. It's when their claim arises.
No. See, suppose company A has defaulted in payment of 1 crore plus to any regulatory authority. So it appear the next day, 15 days later, when? And where?
It will occur the next day, sir.
Where?
In NCLT, sir.
CERSAI.
No. What I am asking is, you will see, perhaps I am going to express it properly. Suppose a company A has defaulted payment of income tax on 1st of January this year. So when is income tax department required as per statute to upload it in some public domain that this company has defaulted?
So they are not obliged to.
So then how can they claim?
Sorry, let me explain. They're not obliged to upload it. If they want to upload it, they can in the IU. Or
They have to be made obliged to upload it.
Sir, the CERSAI rules, the CERSAI is the registry where every secured creditor which is claiming to have a charge on any asset is required to inform by registering of that registry to the public that they have a charge, whether it is a secured asset or an unsecured, whatever it is, whether it's a first charge or a second charge, they are supposed to report. Now, it is for the income tax authorities to decide that if they believe that on a particular due they have a secured charge by way of a fiction of law, a statutory provision, relying on that statute, they have to file a form in CERSAI to claim a charge on that asset on the basis of a statutory provision and inform the public. If So that provision is also there.
Yeah, so if they don't upload it, that means they don't have any charge.
Then they don't have the charge, as the presentation explained in the first few slides, that the RP or the liquidator, as the case may be, is required to verify on the basis of the registration of charge in such INRs. That is a statutory requirement.
Was it there in rainbow papers?
So rainbow paper, that is why the review is being sought, sir, because all this was not considered.
Sir, if I may just add what sir said, that answering to your question, there is no requirement for an operational creditor, mandatory requirement to file the financial information with any information repository. The charge has to be registered with the CERSAI, as sir said. In such cases, they don't have a charge, they don't have a security, they don't have the secured interest, so they're not obligated to file that. How they can file the claim, you ask that. When the claim is invited, they are at the right moment, appropriate time, they should file their claim. That is what Supreme Court has said in many of the cases, and they said very clearly in very harsh word that there should no fresh hydra head pop up after the approval of the plan. So come on time. So time has to be taken care by the authorities that this is my due, I have to claim in this process, so I should file with the IRP at the earliest time before the plan is approved. And that is the only time when they get the opportunity to file the claim. Otherwise, they don't have any other opportunity to file the claim.
So if they don't inform the financial creditors through some means of public domain, what right do they have to claim a charge on the assets?
So I think
I think this is not the requirement of law that the claimant should make a public announcement that I have a claim. I think the employees then will be asked to make a claim and the announcement, and then everybody will asked to make the announcement.
So in the interest of time, we can continue the discussion in person with the presenters. So we'll wrap up the first presentation.
Yes. And what they have held is that constructive notice is to be given, and if the constructive notice after the CERSA has come in, they must register their charge. If they fail to do so, then that constructive notice is not to be regarded, and then the SRKC say they don't have any claim. Yeah, government.
So if they're claiming to be a secured creditor not on the basis of an instrument, which is a loan agreement, on the basis of the statute provision, they have to put notice. And it is for the other creditors to object to say it and say that this is not a valid security, we don't question, and any which way they will.
Excuse me.
So, I mean, difference of opinion is prevailing, Supreme Court generally sees the matter, let us support judgment.
Thank you very much. Thank you for the wonderful present. I'd like to invite the second presenter of the session. So we have Kavya Lalchandani. She is currently an assistant professor at Jindal Global Law School. So her paper is titled Shaping India's Cross-Border Insolvency Framework, Lessons at the Common Law. Over to you, Ms. Kavya. So we have 20 minutes of presentation, followed by 5 minutes of discussion.
Am I audible? Am I audible now? Am I audible? Yeah, now I think I will. Right. So my presentation will shift some gears from the last topic because that was a really technical topic, and now I'm going to discuss the policy question that we are currently dealing with, which is the cross-border insolvency law. For the cross-border insolvency law, we just need not focus on what the law is currently, but we have to delve deeper into the reason why it is what it is. So first question that comes to the mind is, why do we even need unification of laws? So in any commercial setup, it's highly unlikely that I will, from the UK court, a judgment comes and the courts in India will just enforce it as is. even though there is a reciprocity agreement, there are principles of comity. However, that is not true. So, and we also need to understand that laws in different countries develop at a different pace, and they have different priorities, as well as difference in substance and procedure. Therefore, an instrument was required to actually unify the insolvency laws in general. Yeah. Thank you. Now that we realize that unification might be quintessential in today's commercial scenario, what would be the most possible framework in such a scenario is another question that we need to tackle. So the first thing that we really need to realize is why ancestral model law is in a form of a legislative guide instead of a treaty that we could have signed with different countries. Now, there has been a lot of debate about the treaty aspect and how a treaty would be more enforceable, and logic drawn from NAFTA and how it is a better way of enforcing claims within different jurisdictions. However, during my time at Unidroit, I realized that this is not the correct forum for a treaty, because the countries do not want to give away their jurisdiction that easily. They don't want something to bind them on a cross-border level as easily as a treaty would. So my paper is actually divided into 5 parts. The first part is what are the different approaches of the cross-border model law, and what are the different permutation and combinations in which this law can be adopted from ancestral framework. Then I'm going to delve deeper into the core concepts under the model law and how they have been actually interpreted by different jurisdictions. Then I will go on to discuss the allied laws, which is the insolvency related judgments model law and the group insolvency model law, and then India's adoption of draft part C. And lastly, the conclusion. I will conclude while I am discussing different topics. However, if there's any room for conclusion in the end, I will conclude my then. So, yes. So the first thing that we need to realize is that there are two broad ends to the spectrum of cross-border insolvency law. First is territorialism, where wherever the asset of that particular corporate debtor is, that country just grabs the jurisdiction in that particular format. And then following that, they just exercise their jurisdiction and their own laws. Now, grab rule has obviously been criticized on many levels, even when it's a single entity, leave alone cross-border matters, because it not only leads to centralization, but it also leads to destruction of value of the assets. Because then we are not taking into account what other assets the corporate debtor had across countries. Then we have universalism, which is again the opposite end of the spectrum, where there will only be one proceeding and which will be governed by one law, and this will have a worldwide application, and other countries are expected to cede to the jurisdiction of that particular country's jurisdiction. Now we have something which is in between, that is modified universalism, on which the ancestral model law is actually based. And modified universalism is something that every country has adopted in its own way. So when we talk about different hints of modified universalism, the trailblazers were EU and UK, who adopted right when it came into effect. And in UK, interestingly, recognition under their adoption of model law is not automatic, whereas in EU, it is automatic. So the point here is that although these jurisdictions are really closely connected to one another, they still do not have the same level of adoption of the model law. And then there is, of course, the US, who also, which also has a form of modified universalism, where they just say that modified universalism is a good practice in some judgments, and sometimes they just refute it as being an aspiration and not a reality. And then we need to understand that it's not just ex post effects that we are looking at. We also need to understand how ex ante effects are really affected by choice of law in this particular scenario. Ex ante effects could range from cost allocation to even the interest rate at which a creditor would grant credit to that particular corporate debtor. And lastly, I would just like to conclude this bit by saying that although modified universalism is what is being adopted by different countries, there is always a risk of forum shopping, because as we will discuss the concept of center of main interest shortly, we will go deeper into how India has tried to really tackle that problem by giving a 3-month period as an ascertainment period for determining the center of main interest or an establishment. Right. So the first thing that we really need to understand about cross-border model law is the center of main interest, and how there is a presumption that the registered office will be the center of main interests. And this presumption is usually a rebuttable presumption, and this can only be rebutted where it is ascertainable by third parties that, okay, these, according to these factors, the registered office place would not be the center of main interest, it would rather be somewhere else. Now, there's a difference of approach again, and India needs to look into what approach would it be comfortable in following. First is the approach in the Europe, UK, New Zealand, and Australia, where it's not easily rebutted. This presumption is not easily rebutted. The rule of thumb here is that the registered office is actually the center of main interest. Whereas in US and Canada, what actually happens is they look into several factors that could be taken into consideration. Now, there are a series of judgments and where they have actually not upheld the center of main interest as a registered office of the corporate debtor. So Canada takes into account various factors such as headquarters of the functioning of the corporate debtor, where the key personnel are based off, and where the centralization of key corporate decisions takes place. In the US, interestingly, even if it's a single debtor, even then what happens is if the registered office is not where the main operations of that particular corporate debtor are actually functioning, they would hold that the other place where they have the closest connection to will be held as the center of main interest. Now, what a tricky beast is in the cross-border insolvency is the public policy exception. And this exception has actually given a rise to a lot of debate because of one word that has been used in the ancestral model law, that is manifestly. Now, because of this term being used in the ancestral model law, what has happened is that it is now construed very narrowly. So, we are not even sure that if public interest or economic crisis for a particular country would actually be a part of this of the public policy exception. Now, quickly moving on to the allied laws that I had to discuss. So the first thing that I'm going to discuss is the insolvency-related judgments model law. And what is insolvency-related judgment is, of course, there's a definition that has been given under the model law itself, and it can range from avoidance transaction to a resolution plan being approved by one of the courts, and it is treated as an insolvency-related judgment and not the insolvency judgment itself. Now, interestingly, there's a Singapore judgment that has just come into picture, and which goes by the name of Ray Tantleff. And the Singapore High Court had categorically not recognized that insolvency-related judgment that was passed by the US on a simple ground that real estate investment trusts are not actually a part of the Singapore law. Although they did agree that they could recognize that particular judgment under common law, they still went ahead and not recognized it because insolvency-related judgments model law actually gives them that benefit of refusal, and the grounds are expanded in the model law itself. Now, secondly, model law on enterprise group insolvency, when I wrote this paper, part ZA was not publicized at that particular point of time. And ZA is something that is based on the enterprise group insolvency by ancestral, but it is only for a domestic setting. It doesn't take into account the cross-border group insolvency framework. So the only suggestion that I would like to make over here is that when we are adopting this framework in the domestic setting, I don't think anything would really stop us from adopting this particular aspect on a cross-border level as well, since we are in the process of adopting cross-border model law. So, coming to the Indian law now, in the Indian law, of course, the current setup that was there under sections 234 and 235, it was not enough to tackle the problems of cross-border insolvency. Otherwise, there would have been no need to develop a separate protocol under the Jet Airways case, or the Supreme Court enabling a foreign creditor to have access in Macquarie Bank versus Shilpi Cable. So, of course, draft part Z follows some basic tenets of the ancestral model law, which is access, recognition, coordination, and cooperation. However, there are a few hits and misses in the draft part Z itself. There are more hits than misses, luckily. So, the draft part Z basically gives a time specificity, like I mentioned in the first 5 minutes of my presentation. And time specificity is basically to ascertain the center of main interest or establishment. Now, time specificity is important to prevent forum shopping. Forum shopping is going to be prevented because the 3 months gap that is given under the draft part Z actually helps in ascertaining the closest in time place where the center of main interest would be situated. Secondly, in the establishment's definition, the word that has been used in draft part Z is assets. Now, the word asset has a wider connotation than the term goods that has been used in the model law itself. Now, the term asset, because the UK has also adopted the definition in terms of the word asset and not goods, and they have categorically held that the term asset will be actually broader in its expression and meaning than just goods. Then, with regard to the public policy exception, I have tried to draw a parallel with Singapore, and Singapore has dropped the word manifestly while adopting the public policy exception. Now, this is obviously legislature's discretion, but my suggestion would be to drop the word manifestly as well, because it's not like Singapore is a very backward commercial jurisdiction, and they have categorically upheld and held again and again that they are going to use this discretion, but narrowly, but they will keep the discretion to themselves in case the need be. And another point that is actually a plus point under draft part Z is that they give recognition within 14 days. And the provisions that would be missing in the draft part Z would be limited jurisdiction, which means the insolvency professional or the foreign representative would be subject to Indian laws, and the assets would also be subjected to the Indian laws. And then, however, there is no provision for interim relief. Now, since we are running against time while preserving the assets, and I understand that moratorium is there, but there might be a particular set of reliefs that might be sought, which could be given on an interim basis, but was not given because this provision is not there in draft Part C. Lastly, there is no provision for intervention by a foreign representative. So all in all, it looks like we are tilting a little towards territorialism instead of universalism. Thank you.
I request the session chairs to provide their comments.
So I feel personally that manifestly can be dropped because I'm not sure whether, since UK is currently under recession, UK having the word manifestly may not be able to avoid any judgment that might be detrimental to the assets which are located in the UK. So my humble suggestion would be we can drop the word manifestly while giving certainty to the commercial world that yes, we are going to interpret it narrowly like Singapore does. However, we will maintain that discretion with us. And I also feel that we can look at UNIDROIT's bank insolvency principle since the financial service providers are not currently covered under the framework. So that would obviously depend. Yeah, so that's why center of main interest is actually important here, because then it is when even in Jet Airways, where the center of main interest was held to be in India, and it was supposed to be dispersed according to the Indian law, the Dutch representative had to come to India to discuss that, and the claim and the law which is applicable to such scenarios is dependent on the foreign main proceeding, which is the center of main interest. That is why we should closely look at which direction do we want to go in with regard to the registered office presumption.
Yeah, so Kavya, I just wanted to get a better sense of how big a problem this is. So like, is there any sort of quantification of how much of this forum shopping goes on, right? Because I imagine, so contingent on like a company having its debt and facing insolvency, it's going to be fairly hard for them to shift jurisdiction. But even otherwise, even if they're thinking of raising debt in a new jurisdiction because the insolvency laws are more are sort of better for them, better suited for them, this is just one factor into the interest rate that sort of that they have to pay, right? Their ability to raise debt and the cost of debt they might face could be higher, and it's likely to be higher in a foreign jurisdiction. So is there any sort of a sense of how big a problem this is?
So according to me, it's a bigger problem because when in the US, when we look at the US jurisdiction, there have been judgments where only the registered office, for the sake of having that presumption in their favor, is in Cayman Islands, which is a more favorable jurisdiction commercially because it's a tax haven. However, the court has to repeatedly circle them back to the US court because their real connection is with the United States. So just because, and if it is narrowly interpreted, when it is narrowly interpreted, then what happens is that when the presumption is difficult to rebut, then what will happen is that Cayman would actually be the center of main interest, and then it would not be fair to the commercial setup in general that some of the resolution happens in Cayman when it should have been in front of the US courts.
Okay, but is there like sort of globally how many firms are sort of doing this? So Cayman, I think, is more of a like the rationale there is to avoid taxes, yes, right? And that would be a completely different sort of a unified legislation. So like, but in terms of insolvency, in terms of raising debt abroad, is there some quantification like this percentage of firms globally are sort of exploiting this
So I'm not aware of the percentage in general. However, if UK will be more favorable jurisdiction commercial to a firm, they would move out their headquarters and head office to UK, but they will still be operating in India. And that poses a problem, according to me. Thank you.
Thank you, Kavya, for your presentation. So now I invite the next presenter for the session, Professor Arya V. Vajwada. He is a professor at Tyndall Global Law School, and his paper is titled The Home Buyer's Conundrum in Real Estate Insolvency.
So today we are here to address the issue of home buyers pertaining to real estate industry. So in this presentation we are going to go over what the current position of the home buyers is, how this position came to be, and most importantly, through a deeper analysis of the law, we seek to address whether the gap between other secured financial creditors and the status of home buyers as creditors can be bridged. So let's have a look at the background of what the position of home buyers under the IBC currently is. When the code was enacted in 2016, home buyers had no rights, had no positions under the legislation. It was not until the 2018 amendment to the Insolvency and Bankruptcy Code where home buyers were brought in to the ambit of financial creditors, where similar to secured financial creditors, home buyers could now institute a corporate insolvency petition before the NCLT. However, the problem remains that home buyers still do not have an equal position at the table of committee of creditors. Ladies and gentlemen, I want you to take a moment and understand the ramifications of this. In India, owning a property is still considered to be a profound form of investment. It is considered to be a national aspiration, and owning a home, especially if it is your first home, is an emotional issue. Now, although IBBI, courts, and the government have recognized their plight and have been trying from time to time to strengthen their position in the legal framework, however, this is not adequate enough yet. So through the presentation, we are going to argue that one significant step which is required to protect the rights of the home buyers is to treat them at par with secured financial creditors in a corporate insolvency resolution pertaining to real estate companies. So in order to drive the argument, we'd first like to take a look at what the relationship between a home buyer and a real estate developer looks like. Can you change the slide, please? So the legal relationship between these two parties starts with the signing of the builder-buyer agreement. Now, this is an agreement to purchase a property at a later date. The duty of the home buyer here is to make timely payments, and the duty of the builder is to hand over possession of the property in a timely manner. However, if the builder delays in handing over the property, or if the builder delivers immovable property which is substandard, the home buyer has the right to seek compensation or has the right to withdraw from the project. Under either of these situations, the home buyer is owed a debt which must be paid by the developer to the home buyer. Now, in the event of the builder going into insolvency, the payment of this debt by the builder is now at the mercy of the resolution applicant. If the professional. Now, if the home buyers are in a majority, they can still drive the process and the terms of the plan. However, if they do not have the voting shares which would make a difference, then they may not be able to draw much influence on the terms of the plan. Moving on, it is with this background that we would like to advance our arguments on the needs of the home buyers being treated as secured financial creditors. So when the relationship between the home buyer and the real estate developer starts with what is ostensibly an agreement of sale, it turns into debt with the application of RERA and with the commencement of insolvency under the IBC. So, as a result, in case there is delay in possession, or either the home buyer will receive the property or he will have the right to withdraw from the project in which he has an interest in. So with this duality, we understand that as a home buyer, either I will receive my money back or I will receive the property. Ladies and gentlemen, I would like you to keep in mind that the home buyer has legitimate expectation and interest to receive either of those two, obviously not both. So now how does the home buyer agreement turn into a security interest? In order to understand this, we must go back to the basics. Section 58A of the Transfer of Property Act provides for 3 key characteristics for a mortgage to exist. Firstly, there must be a transfer of interest in a specific immovable property. Now, this transfer must be used for the security of the payment of a loan. It need not be a loan, it could be an existing debt, a future debt, or the performance of an engagement, which may give rise to a pecuniary liability. Now, this pecuniary liability is very important to the argument that we are making. If the nature of an interest in immovable property can satisfy pecuniary liability, then it takes on the characteristics of a mortgage. Delving into this a little bit further, one party has a pecuniary liability against the other, which means that one party must make some sort of payment to the other. Now, instead of that payment, I can transfer interest in property, which then my pecuniary liability gets satisfied. So this is the entire core of a mortgage. Moving back to the real estate issue, we have already understood that under RERA, there are instances where a builder can have certain debts. Non-performance of this debt gives rise to pecuniary liability. I would like to mention that this liability does not arise from the builder-buyer agreement, it arises from under RERA, hence it is a statutory pecuniary liability. There what we see is that the builder can either hand over possession or he can absolve himself by paying the necessary compensation. Now I'd like to refer to the case of Umang Realtech, where in para 10, the NCLAT had clearly stated that unsecured creditors have the right over the assets of the corporate debtor. They mention this as under the code, secured financial creditors such as banks cannot have rights over these assets. Now, when the NCLAT is saying that unsecured creditors have a right over the assets of the corporate debtor, is the NCLAT in cloaked terms trying to tell us that home buyers are actually unsecured creditors and have an interest in their property? When they say unsecured creditors have a right over the assets of the corporate debtor, what is the nature of this right? The nature is that I will have the right to receive the property if all goes well. Thus, I have an interest in that specific immovable property, as we mentioned under the Transfer of Property Act, which may be extinguished by compensation if the pecuniary liability under RERA is paid. Now, moving on. As a result, any payment made by the home buyer under RERA would automatically convert into debt. This is the basis on which the 2018 amendment has been made. And as we've mentioned, undoubtedly the builder-buyer agreement is to memorialize the terms and conditions of the sale. However, because of RERA, we now create a debt against the corporate debtor. And now this agreement to sell turns into a security interest. Thus, the claim of the home buyer rises with a legitimate expectation and legitimate interest to receive the property or compensation. This expectation on part of the home buyer confers an equal and opposite obligation on part of the builder to pay or perform under the combination of the builder-buyer agreement and under RERA. This amounts to a security interest. Now I'm going to read out the definition of security interest as given under the IBC. It means a right, title, or interest or a claim to property created in favor of or provided for a secured creditor by a transaction which secures payment or performance of an obligation and includes mortgage, charge, hypothecation, assignment, encumbrance, and any other agreement or arrangement securing payment or performance of any obligation of any person. Thus, the home buyer has a right, a title, or an interest in property by a transaction which takes on the garb of a mortgage, under which the builder must return the money invested or hand over the property. Therefore, because a home buyer has the right to receive property or compensation acting out of RERA, home buyer is now a secured creditor. The purpose of The purpose of IBC ostensibly is to provide a speedy resolution of issues arising out of solvency of corporate debtors in a timely manner and balance the interest of all stakeholders. However, I would like to draw your attention to the multitude of different stakeholders within the insolvency and bankruptcy process. Let's take a look at the position of non-home buyers. As mentioned in the Ministry of Corporate Affairs discussion paper dated 18th January 2023, secured financial creditors would accept repayment even with haircuts or agree to liquidate the corporate debtor. However, home buyers would prefer ownership and possession of the property rather than repayment of their advances. Due to the uniqueness of the real estate industry, the creditors, which are home buyers here, are more interested in receiving their property rather than their money. Therefore, it becomes even more imperative to allow home buyers an equal seat at the table of Committee of Creditors. The Committee of Creditors, which solely comprises of financial creditors, therefore, it is entirely possible that the interests of these secured financial creditors and the home buyers will not align. Going back to the case of Umang Realtek and the idea of reverse CIRP, where we simply hand over the project to another developer to have it completed. As mentioned in the MCA discussion paper, which I just referred to, in practice, it is observed that there are situations where, because of default in one project, the CIRP is initiated against the entire company. This is counterproductive as other solvent projects are also stalled post-commencement. It is also noted that in real estate cases, the default often pertains to specific projects while the other projects continue to do well. Now, in conclusion, in an insolvency proceeding, all property of the debtor is sold to cover the claims. However, the remaining amount will not be enough to cover the claims of unsecured creditors, which is where the home buyers are currently found. We believe that recognizing home buyers into secured financial creditors will finally accord them of the position that they deserve. Before I conclude, I would just like to mention that our proposition requires answers to a few questions which we have mentioned in the next slide. Firstly, what if in the event that a home buyer rejects the resolution plan, how will their liquidation value be quantified? Secondly, what if the home buyers have only made partial payments for the units? How would the security interest be calculated in such cases? We hope to find the answers to these questions and we will continue our research on this. Thank you so much.
Sorry, I think I once saw that gentleman.
You can take two questions, I think we're running out of time.
This is not a question, a small correction. Under the reverse CIRP, the existing directors, ex-directors, those who are carrying the operation, they complete the project under the supervision or along with the IRP under the supervision of the court.
Alright, thank you.
Thank you. Ma'am.
I'm on. That was a brilliant exposition for law students. So nice. It's not a question, it's more of a comment. Because as a practitioner, liquidation is a no. Payment of fees to legal professional is a big no, which is slightly worrying. What is your suggestion? Because there is now somebody called an authorized representative who speaks on behalf of the COC members who are largely home buyers. But that person is also a home buyer family. There is nothing that sets apart an AP from the rest of them. So do you have a suggestion or you want to work on something that would change this? Because you're very strongly arguing for a case for home buyers to be
I'm happy to take that, ma'am. So I think it's imperative to understand that for a home buyer, this is not a financial decision at all. It is a very emotional one. Obviously, there's no space for emotion in legal proceedings, but I think if home buyers are educated enough, and this falls then to the professionals who are guiding such home buyers, not just at the time of insolvency or at the time of default, but maybe from this time of investment, right? That these are your rights under RERA, these are your rights under IBC. You will have to stick to this particular framework. There's no other way around it. I think these are issues that will iron themselves out over time as more and more home buyers either get into disputes with real estate developers or such issues, get ironed out in the court over time. So I think this is just a function of time. Does that happen?
I mean, that's true of all of IBC, it's not just the case of home buyers. We're a very immature jurisdiction.
But it's the same problem, by the way, that we see with class action suits under 245 to 242, right? Even there, you've got minority shareholders who have no idea of how the business ought to be run and who are actually part of that process. I think we can take one more question, sir.
There was a question.
Yes, sir.
And then I have one.
So we can't hear you. So
Little closer.
Hello?
Yes.
Can you hear me now?
yes, sir.
Okay. Now what you have mentioned is, according the financial creditor status to the home buyer, that is okay. That is as far as the legal aspect is concerned, they have been accorded a higher status in the table and they are targeting for and all that. But that does not solve the basic problem in case of a project which has been abandoned by the builder, having taken assuming 50 crore rupees loan from the bank, and with home buyers having invested another 50 crore rupees, and then leaving the project, abandoning the project. Now, you have to find not a solution means another person, another builder who can pump in 100 crore rupees. No, without addressing this basic question of 100 crore rupees, we cannot proceed with that handing over the possession. What you are saying is, under RERA, they are eligible for compensation. But who is going to give them the compensation? The builder has already run away. And third aspect, what we are normally we ignore in all these RERA projects, other things, housing projects, apart from the builders and the buyer, there is also a third party who is actually not visible. He is the owner of the property. Builder is only an agent. Builder has no financial stake. It is the owner of the land who has taken upfront money from the builder and he has run away. Now, we don't recognize him at all. Now, the problem of the home buyers is, the builder has taken 50 crore rupees from here. He has invested 75 crore rupees in buying another project, the third project, and he has abandoned it. He said, it is your funeral. If you want, you take it or leave it. It is none of my problem. This, your RERA or other thing, IBC has not addressed this basic issue. So that's why even today, Amrapali or JP remain unresolved even after so many years.
Perhaps one reason why the original landowner has not been addressed in this entire scenario is because there is no contract particularly with the landowner per se, right? The contract is between, is effectively the sale of space hanging in midair, an apartment, between a builder and the homeowner. So the landowner somehow, I agree, gets completely lost. So we have a...
Right, so first of all, great presentation, Mary. I think it's a very interesting idea that you proposed. I don't have a question, I just have a suggestion which may or may not help boost your argument. So typically, secured creditors, when you sort of look at like from the debt perspective, they typically have lower interest rates than unsecured creditors because they're getting that collateral sort of in addition. And these home buyers that you're sort of talking about, because they're buying unfinished properties, typically they would also be buying at a discount. So it might be a good idea to compare what is that percentage of discount and whether it sort of more closely resembles the secured interest rate or the unsecured interest rate to sort of determine, where, like at least how the builder perceives this sort of entity.
Right. Thank you very much for that suggestion.
Thank you.
I have one observation on your paper and one on your presentation. In your paper, you are giving two theory to consider the home buyers as a secured creditor. One, that it is the transaction is more closer or akin to the mortgage, and also it involves a floating charge. I have my doubts on that. The mortgage, I think, this transaction between home buyers and the builder through BBA or the rights under the RERA do not convert the nature of the transaction to a mortgage, because mortgage is the transfer of interest in the property to secure a loan. Here, he is paying the money to buy a future property. There is no transaction of financing the property or securing loan payment of a loan. So I don't think it is a mortgage. So secondly, your paper also suggests about the floating charge. Floating charge is also having the component of the fixed charge. In the maturity of certain three conditions, it becomes a fixed charge. That is more akin to the debentures, pledges, not to the home buyer and the builder agreements. So how I think that the doubt itself exists, how they could be still in the present dispensation who considers a secured financial creditor. There is no doubt about that their financial creditor, there is a debt in, because there is a time value of money and the commercial effect of borrowing, everything has been settled. But whether they would be treated as secured financial creditor, that would be a debatable question. Your paper is not dealing with that, how there could be a mortgage and how that could be a floating charge.
Right, if I may just address that.
I just want to make one more response to this. See, the home buyers, while entering into sale date, they parallelly get finance from a third-party banker. 90% or 80% of the home finance is invested into it, and that is more or less the rate of interest is comparable to a secured financial creditor who is giving project finance. Same home buyer buys at the rate of 8 or 9% from a third party. Today, what is happening? The third party financier is not giving a secured interest because the home buyers is not secured. So he is left alone. To that extent, the same banks are affected who would have given home buyer finance, who would have given project finance. To the extent of home finance, they are affected. So this.
If I may.
Good idea. You have thrown a good idea to treat them with the.
So if I may just connect the 2 points, the home buying financier seeks a mortgage on property that is yet to be created. If I am entering into a home loan, I am saying that if I default on my home EMIs, my home goes to the bank. I cannot get that unless I am a secured creditor myself. That's one. Second, the issue of the mortgage arises out of a lack, in my opinion, arises out of a lack of intent. When I am entering into a builder-buyer agreement, my intention is to sell property. My intention is not to create a secured interest. So what our argument suggests, and yes, it is an argument only, it suggests that at the time of entering into the builder-buyer agreement, the intention is to sell property. But by action of RERA, this becomes a debt. And because the debt is backed by, or can be released by the performance of the builder who is handing over the property, it takes on the garb of a mortgage. Again, I'm not suggesting that this is the correct position in law.
Financial debt by virtue of IBC itself, not RERA.
I agree.
Declared that financing is a financial dead.
Correct. And that's the 2018 amendment. What we are suggesting is that because that debt is backed by an immovable property, it meets the requirements of Section 58A.
So that first limb of your argument, that
good argument.
Because you're not a financial creditor, the bank financing you cannot then become a financial creditor.
By
no, I beg to differ, because whenever you approach an institution for a home loan, they look at your eligibility to repay. They do not ask you for the valuation of the asset that you are going to purchase. So actually, the investment by the bank is in the person's ability to repay rather than the asset that's going to be constructed.
Well, I'm not a banker myself, so yeah. So
Incorrect.
So banks will do their own diligence on the builder. We should stop.
Good discussion. Thank you.
All right. Thank you very much.
Thank you for the discussion. So now I would welcome the next presenter, Ms. Diksha Dhingra. Is the presenter here, Ms. Diksha? No, Diksha.
Sorry for being late. We were confused about the rooms, and we just got down, and we are the youngest ones here, I am supposing, because we will be entering with our 5th years and seeing all of you dignitaries out there. It's just so amazing to have this platform out there with this conference, and so yeah, I'll not waste much of your more time. So good afternoon all. Our topic is individual insolvency under IBC, critical analysis and the way forward. So in this paper we have evaluated that why there is a need for an individual insolvency legislation. We evaluated that the core legal registration according to World Bank reports. We evaluated the existing laws as per Indian insolvency, USA, England, and with respect to how the comparative analysis goes beyond. And then we'll be concluding it with how the way forward goes upon and how the concluding remarks would be. So why there's a need? We could see that there's a rise in the rate of personal insolvency market on personal debt levels. People finding it difficult to repay loans as for that matter. There's a promoting in entrepreneurship skills that are needed for that. There's a higher growth rates for personal insolvency, and the existing two frameworks that we have at hand, Negotiable Instruments Act, the 1881 Act, and the SURFACI, there's a lack of inefficiency amongst that act. Then it contributes to the overall economic growth. There's increased consumer lending, there's business growth, etc. And I think the absence of a reliable procedure is the main detrimental effect of what goes on. And World Bank will be continuing? Yeah. So Diksha will be continuing the World Bank reports on the further issues.
So the World Bank's report on the treatment of World Bank's report on the treatment of the insolvency of natural persons 2014 is a report which was published by World Bank. And according to the report, there are several parameters according to which every country decides what is a suitable legislation to govern individual insolvency in that country. The first parameter being general regime design, which refers to the role of informal procedures in solving insolvency matters, because the dependency individuals have on the informal regime is related to how the number of people who'd be referring to the formal regime and number of people that legislation will have to cater to. And as much as voluntary conciliation has its benefits, there seldom do creditors wish to resort to voluntary measures, which is through the informal platform, because what happens is creditors become adamant that they want the entire amount which is due to them, which is the reason that most countries opt for a formal design of regime. Second parameter which is provided by World Bank is the institutional framework, which gives different options to countries from which they can choose. These include that systems where administrative agencies oversee insolvency procedures, or a hybrid of public and private, and court-based procedures. Most countries resort to the court-based procedures with the help of intermediaries, because that is one situation which is mostly suitable and most convenient for people. The next parameter would be the access to formal insolvency regime. Access becomes very important because in an individual insolvency regime, the target audience, as the name suggests, is individuals and not companies or corporate houses, as in the case of corporate insolvency, and therefore it is all the more important that access is easy and the resolution process is faster and not cumbersome. The next point is the participation of creditors, which means that the degree of participation which is going to be seen by different creditors. For example, secured creditors do not have much of a say when it do not really come as the target audience when it comes to individual insolvency regime, because these people for now have the option to exercise and sell the assets which have been secured to them against their loans. Solutions to the insolvency process and payment of claims. This refers to the challenges which come with respect to extracting payments, not just from the current assets of the individual, but also from their future earnings. For the time being, most countries do prefer, at least initially, to focus on the current assets of the existing assets of the individual in the initial stage of the regime, and maybe later focus on the future earnings of the individual. Then for determining which categories of assets are exempted, it is usually either an amount is set up to which whatever assets the individual believes are going to be exempted to them, but most countries follow that specific categories along with a specific amount cap is exempted to individuals. After that, we have covered how the IBC refers to individual insolvency. For now, it is with regards to personal guarantors, but we expect how this would go on even for individuals who have become insolvent or get into the same procedure. Under this, for now, the eligibility is that a single default of 1,000 rupees is sufficient, and it provides that it can be increased up to 10 lakh rupees. Either the debtor or the creditor could file this application. However, only a debtor can file the fresh start application. Next would be that filings can be made only if they don't come under the excluded categories. The processes which are provided for now include the IRP bankruptcy route and the fresh start procedure. Under the IRP bankruptcy route, the debtor comes up with a repayment plan, which is implemented with the help of RPs, and then it's assented to by the DRT. Under this scheme, under the supervision of the RP, the debtor would be required to propose a repayment plan, which has to be accepted by a majority of creditors, which means that 3/4 of the value of the creditors have to approve of the plan. The IBC, however, does not give any direction on the content of the repayment plan and does not require that the plan has to provide the debtor a minimum quality of living. After that, the fresh start route refers to a process which is intended to provide. The fresh start procedure is a route which is intended to provide relief to the poorest of the poor people, and it has certain eligibility criteria fulfilling which can an individual resort to this route. Otherwise, they have to compulsory go to the IRP route. The eligibility criteria for the same are that the gross yearly income is less than 60,000 rupees and assets have to be less than 20,000. However, the most important eligibility criteria for this is that the individual should not own their should not have their own residence. And if they fulfill all of these three conditions, they are eligible for a complete debt waiver. This is under this route, only a debtor can file the application, and when an RP provides the recommendation for acceptance of this procedure to the DRT, will the DRT assent to it, and then they can enter into this route. The priority for repayment, however, has not been provided for a repayment plan and is only in the case of a bankruptcy where for now the procedure, the priority is provided as to how the repayment has to be made. There is no recommendation on how the DRT shall make decisions regarding the RP's recommendation of whether a fresh start route should be accepted or not. There is no clarity on whether the DRT should completely just agree with what the RP is saying, or they can use their own application of mind to decide whether the individual should be eligible for the Fresh Start route or not. For comparison, to understand where the Indian legislation should be headed or how we stand today, we have made a comparison between, we have also tried to understand the US legislation and the legislation in England, because they have been implemented for far too long, and we can learn from the mistakes and learnings in their legislature. For example, in US law, their insolvency can be initiated under two chapters, which is Chapter 7 and Chapter 13. And under Chapter 13, the current the existing assets of the individual are used to repay the creditors, but they have exempted assets, which means those assets will not be used for repayment, which are prescribed by different states at different levels. However, principally these include their own housing and principal amounts of vehicles, clothing, tools in trade, etc., which is the same exemption which is being used for personal guarantors even in India right now. The second option available to them was Chapter 13, which meant that all of their existing assets stay with the debtor, and it's only the future earnings of the debtor which are going to be used for repayment. However, the problem which this legislation faced, that they were given absolute choice with the individual to choose whether they want to opt for a Chapter 7 or a Chapter 13 insolvency route, and which was misused highly by individuals, because when they used to convert their non-exempted assets into exempted assets before applying, and since there was no amount which was provided for a repayment plan, that this is the amount which the debtor compulsorily has to spend on repayment of his future earnings. What happened was, when they were given absolute choice was given to the individual, their ability to pay and the actual amount they were paying did not have much consonance, because of which an act was enacted in the US, which is called Bankruptcy, Abuse Prevention and Consumer Protection Act 2005, after which the choice from individuals was taken away. I think this is one learning which has already been incorporated, given that we have an eligibility criteria for the Fresh Start route since the very beginning. Secondly, we look at the individual insolvency laws in England, which provide that it can be done in either two circumstances. If the individual themselves is unable to pay their debts, they can apply, or if £5,000 or more is due to the creditor can file an application. Two procedures which are available in England are the individual voluntary arrangement, wherein the debtor and the creditors can enter into a voluntary arrangement. However, it has to be approved by 75% of the creditors, and it has to be under the guidance of an insolvency official, which is like a resolution insolvency professional in the Indian context. The debt relief orders is something which is similar to the lines of a Fresh Start route which we see in India. We can assume that this was one legislation which was considered while adopting the eligibility too, wherein it says that £15,000 and assets under £300 based on gross and not on their net value is when people can be given a complete debt waiver. From all of these combined, we can come to the conclusion that a bankruptcy becomes more pro-debtor when the amount of debt discharged, which is the amount of debt which is foregone and an individual is not liable to pay anymore after the proceedings are completed, that is the amount of debt discharge, or the exemption levels, which is that the amount of assets or the criteria of assets which are given under the exempted assets are higher, and the bankruptcy cost, which is the cost of the complete procedure, is going to be lower. All of these tend to show that it's a more pro-debtor. However, we believe that the insolvency regime for individuals we follow in our country should be mildly pro-debtor, and not the case as we saw in US before the enactment of BACTA, because even though it's important that debtors do not bear the brunt of it completely, it's also important that this protection given to debtors does not come at the cost of the creditors. However, additionally, we believe that the eligibility criteria for filing an application, which is 1,000 rupees at the moment, is extremely low and should be increased so that the courts are not completely burdened by the increase in applications. And also, we believe that DRTs, like earlier pointed out, that there has to be some regulation pointing out the powers of DRT which they can exercise when it comes to approval or rejection of repayment plans or the fresh route process.
Yeah, so just shortly continuing the way forward that we have. So there are a few concerns that are needed to be addressed for this entire regime to happen. So there's an entire need to create that awareness among that individuals for the personal insolvency. The implementation of technology should be there so in order to simplify that process. And when it comes to the time for recovery, the impact of all the expenses that are there, that determines will take place over a longer period of time. Because how the current creditors react would depending on these and coming to the policy issues or the structure of institutions. So there's supposedly there should be a balance between the interest for creditors and debtors, because excessive credit is happening and there should be a compassionate, equitable growth in order to promote, the risk taking or the entrepreneurship skills that are needed to happen. And defining of assets, the repayment plan forward, that should be there. There should be a fast track process. Credit rating should be there. Should be a fees for that. This entire should be covered under the courts part, under the policy issues part. And coming to the courts, there is an increasing burden on the courts. So the number of judges that are there, the quality of the process, the tribunal service agency should be appointed, and the services to the tribunal for the information utility as well, because there are like private businesses that can build IUs and facilitate the technology better than the government itself. Then coming to the intermediaries, the several cases of the mis-selling of the retail sectors, because there's high pressure amongst the sale members. There's confused, biased advice when it comes to whether to file for bankruptcy, whether to file for reduction, whether to file for resolution, whether for filing. So there's a confused, biased advice among that. And then coming to the education and credentials of IP, their regulation and their coordinated features around that. And lastly, I think the credit market is essential for economic growth. The priority should be for debt relief rather than the operationalizing of the entirement, settlement and the bankruptcy process. So the personal insolvency cannot have any impact on high quality rules. There should be changes in the institutional frameworks when it comes to IUs and DRTs. And consulting services with respect to bankruptcy should also be done. And premise is basically that the reform processes should be cognizant of the load-bearing public domain that we have in hand, and raising what we like, because there's political meddling happening at that level as well. So yeah, that would be all.
Thank you. So now open for the questions.
Friend, I'm happy that you touched an interesting chapter 3 by VC course. Way forward, you have initiated some thoughts. I have 3 propositions which the youngsters should actually further study, and maybe you can include it in the paper. One is, loan has to be defined. What kind of a loan? If you look at the Indian economy, 50% is under unorganized lending, for which the individual is the borrower. There are people who are borrowing at 10% interest per day, not per month even. Number one. Similarly, there is a kind of a amendment that is required to HUF law and Vitakshra law. Because if at the moment I am married, a HUF is formed. So my property becomes my HUF property. So what is my property? What is my HUF property? The segregation is essential. So income tax aspect has to be further studied. Last but not the least is political dimension.
So I just would like to ask, a couple of questions. Firstly, in terms of the core deficiencies of the law, I only felt like 2 points that you sort of conveyed. Firstly, it's that the threshold is too low, but I feel even if you raise the threshold, the strategic sort of bankruptcies the problem that you're concerned about won't go away, because most of the the ones for the banks, the ones who are strategically defaulting, the bigger problem are the ultra rich people, right, who are sort of defaulting on crores and crores of loans, not the 1500 guy. In terms of the court sort of like the cases they handle, maybe that could reduce, but I'm not really, you've not quantified how much, how much strategic bankruptcy is going on to begin with. Also, secondly, the other point that I sort of understood was that, you sort of recommend the legislation to be mildly debtor friendly. Although I didn't understand what the logic behind that was, right? I understand the logic behind having a debtor friendly regulation, because they have lesser bargaining power than creditors. But why mildly? Why not strongly? Like, why move sort of position there? What is the logic behind that?
So the logic behind referring to it as mildly debtor friendly is because the position in US where the debtor was given complete option that they could choose whether they want to repay the loans of the creditors from their current earnings or from their future earnings was misused blatantly and led to a lot of problems. So when we say mildly debtor friendly, it meant that only those there should not be a blanket immunity given to debtors where they're given 100% choice of where they can choose whatever they want to, but there should be choice which gives them enough space that for giving them exempted assets that given on a case-to-case basis what is necessary for that individual can be exempted under those assets. But it can't be that they can completely choose, like if they convert their non-exempted assets into exempted assets say before 6 months of the filing, those should be included even if they fall under the exempted assets category. That is what we meant.
I understand the suggestion, but my sort of question related more to why is there a need to move in the first place? So you mentioned that there were some problems that arose in the US. I think maybe in the paper or in future presentations you could sort of explain that bit a bit more. I think that's just a suggestion.
Sir, one question. Can I have that speaker? Can you hear? Very reason that we have not introduced it has not that personal insolvency and partnership, include partnership and proprietorship also, it has not been notified. Basically for the simple reason, it is actually a too expensive a process for a very simple ailment. So if I have a small minor headache, I will take an aspirin or I will go to a clinic. What this suggests is, you go to a super specialty hospital, undergo operation of brain surgery, and then come out and then take some medicines for another 6 months. Who is going to bear the cost of it? If you have to have personal insolvency, the number of borrowers we have in India are running into hundreds of crores. You need to have one DRT at every taluka level. Okay, what is the cost of that? Who is going to bear the cost of it? Cost of expenses. How much staff you require, and then what is the fees you are for 15,000 rupees you are paying. Maybe IP you will pay 1,000 rupees or 500 rupees. He may not agree to come. Who is going to bear the cost of it? No, you just understand it. The problem, magnitude of the problem. Then you say first fresh start. Fresh start means everybody will say, assuming that there are 50 crore people are there who have taken 1 lakh loan, and they say we will start fresh start. So 50 lakh crore rupees loan will be written off. Whether our economy is in a position to absorb that kind of a loss, it will become an economy of freeloaders only. If you say debtor friendly, mildly debtor friendly means it is already excessively debtor friendly in our country, our regime, because 2 lakh crore rupees or 10 lakh crore rupees of agriculture loan is not paid in the bank. We do not talk about MSME, which is another 15-20 lakh crore rupees is not paid. We talk about only corporates. Because we say, because of, if we do it, it's a politically, it's an incorrect statement, we don't want to talk about it. And today, you bring the insolvency regime, you write off everything. Why do you simply write off? Why do you want an insolvency regime for it? You pass an executive order. The government had passed an order in Parliament waiving 98,000 crore rupees agriculture loan. That is a much better, cheaper alternative and more popular than this insolvency regime. I don't think his insolvency regime is going to work, even if tomorrow it is notified. These are my submissions. Please take it to account.
Thank you so much, sir, because initially it should open for a selected number of borrowers and then personal guarantors, and then it should lead further on be executed upon this.
Thank you for your good presentation. I think there are students that have brought out the
last question.
Legal,
We'll take the last
they have brought out the legal structure available, and they are suggesting within that some suggestions they are making. They should not be found part with the practical problems which we are facing. I think you have made a good presentation. I think you can improve as the audience is saying, and bring up better. Thank you.
In my view, only section 95 applications coming in, the person given guarantee to the banks, majority 95 cases coming. My question is, if individual worth of like a 2 crores, for how many crores you can give guarantee? 500 crores or 1,000 crores? Is in the RBI guidelines is there? It's just to study on it, because it is a person worth of 1 crore, don't give 5,000 crores, 2,000 crores. It's only paperwork. It really is not able to pay when the question comes. Let's just study on it. Anyway. Thank you, sir. Here we are at the last presentation of the session. So the presenter is Mr. Ravindra Bellu. He is the proprietor of Bellu and Associates Chartered Accountants based in Bangalore. So the paper title is going to present is Impact Assessment of Avoidance Transaction under IBC 2016. Over to you, sir.
Good evening to all of you. The agenda for this particular next 20 minutes is briefly touch upon objective methodology and research constraints we had while doing this paper. On a lighter note, I found preparing and filing a avoidance application is much easier than writing a paper. So the challenges, whatever we face in writing the paper, we did face the same problem while writing the paper. Then I understood the research is not a easy easier as such. So then we touch upon research findings and the issues observed. Then some thought about the way forward and recommendations, if you may call so. The thinking why we need to do this research came because we have been seeing and talking and listening about the huge haircuts. So the thinking was that whether in all CIRPs, wherever there are huge gaps, whether the avoidance applications have been filed or not. How many cases the avoidance applications have been filed, how many have not filed. Wherever they have been filed, whether they are adjudicated favorably, unfavorably, whether the adjudication, wherever the favorable adjudication has happened, whether they have been challenged, not challenged, whether they have been recoveries. So these were the thoughts when we started this writing the paper on this. The research methodology we have adopted is we have reviewed some academic research papers related with the topic. We have analyzed the data we have obtained from IBBI and some data on the public domain, and we have gone through many of the orders and limited analysis of data statistics about the resolutions and liquidations, linking with the data, whatever data we received from IBBI related with the avoidance applications. Yeah, research constraints. It was difficult to, we had issue in obtaining all the orders of the adjudicating authority in respect of avoidance transaction. We intended to go through each and every order passed in this case as mentioned in the data given by the IBBI. We couldn't trace because of some NCLT website issues possibly. And we could not get the entire details of under what section these applications have filed. And we had also limitation of able to do sanity check of the data. For example, when we got the data, it was about 890 or something. Now, if you see the, because it is a continuous process at any institution, including IBBI, if you see the December 2022 newsletter report, we see only 815 applications. There may be many combinations which would have, maybe the double count or so some of these things were corrected. So this is what I mean by sanity check. And we had an ambitious project of sending to the, must be 2,500 IPs using SurveyMonkey, thinking that if you send by Google, they may not care. But our experience of the survey was, somebody told 50 out of 1,000 surveys, ours was dismal. Even I think we did not get more than 30 or 40 responses. We have not used those responses in it to the extent of challenges we have used, not otherwise. So I realized that what is the what you call challenge of a researcher regarding the when they send the research papers, but I promptly have been doing that. If there is any survey sent by any researcher, promptly I respond, and now all the more it is a case for me to respond, because what you know what you feel when you don't get the response. What is the origin of avoidance transaction? I mean, it's one of the books of an Australian author. He says this goes back to Roman Empire, that is almost 2000 or 2200 years old. It says elaborate provisions for vitiating fraudulent transfers of property was there in the Roman law. That is what they say. But in a recent times, if you see, the formal mention of the avoidance transaction could go back to, I think, 1880 or something. In one of the debate before the act at UK was done, it says the primary duty of the receiver would first to investigate the conduct of the bankrupt and the circumstances that had led to the bankruptcy, and also to any misconduct on the part of the bankrupt which might have been disclosed in the course of the proceedings. So these are the words. I just want to just mention, I should acknowledge that whenever I was having doubts, I used to go to Mr. Sumant Batra's book on insolvency. I mean, this is a very old book. There is one chapter called Twilight Zone, which has very much relevance for this this avoidance transaction. So I just acknowledge that, because whenever I think of avoidance transaction, my mind goes to Twilight Zone chapter. Our findings, this is the latest newsletter, which I want to only highlight that there are 847 transactions, applications have been filed for 847 cases, and the value of those avoidance transactions is to the tune of 283,000 crores. unfortunately, only in 143 cases there have been orders about which is value worth about only 5,083 crores, not 5,083,000 crores, it is 5,083 crores. And out of this 5,083 crores, I think the one case of JP where there is a Supreme Court, it is more close to 5,000 crores. That is the findings. Number one, these are all the data up to 30th June 2022. There were in successful resolution matters, 364 cases, no applications filed, or 5 applications filed is only 153. Similarly, those went into liquidation, there have been application filed only in 328 cases, and in 1,375 cases, no avoidance applications filed. And coming to the IPs who have done these successful CIRPs and liquidation, only 36% of the IPs who handled these cases filed the avoidance applications, 64% did not file. See, filing or not filing has relevance when we see at the what were the admitted claims, what were the amount realized by the claimants, and what is the haircut to the claimants. And we see that, for example, in case of CIRP, successful CIRPs, admitted claims were 767,000 crores. Amount realized by those claimants was to the tune of 235,000 crores. The haircut essentially was 532,000 crores. Of course, 235,000 crores is almost more than 200% of the liquidation value. That is a plus point. But do we mean that the gap between 532 and 37 did not have any avoidance transaction? Is a question mark. And I mean, I have a practitioner's bias because I am an insolvency professional, myself an insolvency professional, having handled the cases. I have not been able to say that, what I say, it has so happened that I cannot say that I have not filed in even one of the cases. In all the CIRPs or liquidation I am handling, it has so happened that for my bad luck or good luck or whatever, I find the avoidance transactions appearing like an elephant in a room. So this is the context. Then in liquidation, the admitted claim is to the tune of 820,000 crores. Of course, we don't have the comparable value of amount realized because lot many dissolutions have not yet happened. So we know only when the dissolutions happened what is the haircut they have realized. But I think you can take it that, say, there could be a haircut of, say, 70%. Then also if you see the value of preferential, undervalued, fraudulent and extortionate, that is the PUFE, the short form of PUFE, filed are only to the tune of 129,000 crores. And the next is the huge delay in filing of the applications by the insolvency professionals, as well as the delays in adjudication or non-adjudication. I say non-adjudication because we have taken the data as on 18th November 2022. So it is not that whatever the applications were filed have been decided on that day. So we have taken whatever the status as on that date. For example, this may not be realistic. 169 days is not realistic because the adjudication, it is the number of days from the date of application, not up to the date of adjudication. So on an average, it has taken 542 days for 96 disposal of the 96 applications. Status of applications filed. In ongoing CIRPs, 332 cases were filed, 23 are disposed of. Similarly, liquidation cases, 328 filed, only 45 disposed of. Successful CIRPs up to, as I said, 30th June 2022, 120 cases ongoing, 31 disposed of. If you talk of the value realized or favorable, I think I can't say value realized, it is the value of the favorable orders. It is about 5,564 crores. I have noticed that there is a correction in the newsletter December. It should come down by another 500 crores in respect of the what you call JP this one. So it is actually about 5,000 crores only. I have already mentioned that JPC is the major, otherwise it is very negligible. Now, these are the quantitative data what I shared. Otherwise, dismissal of many avoidance application in view of the Venus High Court decision. So it is, at least I can remember, I think there were 16 to 20 applications. They were just dismissed by the honorable adjudicating authorities, giving one line. In light of the Venus judgment, this has been dismissed. And there are judgments where it says the avoidance applications were not adjudicated before the approval of the resolution plans, referring or not referring the Venus judgment order. Venus judgment order is that it said that if an RP has filed an avoidance application before or after the approval of the resolution plan, it cannot be continued. He becomes ex officio, what is the word?
Ex officio.
Yeah. So that is the word used. And based on that, based on that judgment, many applications were dismissed. Subsequently, in January, this particular judgment, which of the High Court, which was done by a single judge, has been reversed by the two judges bench, and they have said it can be continued. There is no connection between the approval of the resolution plan and the avoidance application. Of course, the proceeds should go to the creditors and not to the successful resolution applicant. I think I was at another session where this same avoidance application topic was there. I understand that this particular judgment is also before the Supreme Court, and I am confident that it would be upheld because of the logic. And non-prosecution by IPs, it is not only the adjudicating authorities not dismissing that, but in many cases the IPs have also said that we are withdrawing because of the Venus order. That has also happened. And huge disclaimers by forensic auditors, transaction auditors in their reports. Lack of material evidences to prove the avoidance transaction, including high degree of proof which is attached to the fraudulent intent. So I just want to tell one word about each of the cases. Tata Steel, I think we have already dealt. The first two are whatever I mentioned about the Venus judgment. 63 moons is about some 43,000 crores value of avoidance value being given to the benefit to the SRA at 1 rupee. That is also the NCLAT has not found it appropriate, and it has referred it back. And JP Infratech we have already touched upon. This Prashant Chandra Rath is an interesting topic where the RP files an avoidance application and he files a resolution plan by the same promoter director. The Katak bench says, how can you do this? Then it, in fact, it's very harsh. The bench is very harsh on the RP also. Where it dismisses, not only dismisses, it puts the company into liquidation, they appoint a different liquidator. It is upheld by the NCLAT. So I shall, I think I shall go to the last point because of time. 66 subsection 2 is a fantastic section to hold the directors responsible if they have not acted appropriately to protect the interest of the creditor when they see that this company would be insolvent. This international case, this is an international case, New Zealand. It is a fantastic case. It is a 186 pages case. If IPs go through that case, then they know what is their duty, and it is a fantastic case. So it says, of course, there one of the case they dismiss because it said after and whatever the loss has incurred, the director has to be responsible. That argument was not well taken, but whatever the additional loans, additional commitments the company went into, this is actually appeal. Now this case also is before the Supreme Court. We may expect sometime during this year a final judgment. It said that we don't agree with all liabilities, but the specific liabilities which have been incurred, that needs to be valued, and that the director should bring it back. So I think I'll skip this because of the time. Challenges faced by IPs: lack of availability of information, data limitation, inability of IPs to take physical custody, control of the assets, which is very critical in my view. Otherwise, you can't function, and forget about filing any avoidance applications. Time constraints for investigations, getting effective forensic audit reports, lack of funds or non-approval by COC, delays at NCLT in adjudication, uncertainty of continuing application after the plan is approved by COC, estimating value of PUFE transactions, capability issues with IPs. When I say capability to issue with IPs, this law was new, and the IPs from every walks of life, the people from every walk of life entered this profession. Not necessarily they had run the businesses, or they had the clear idea about the avoidance transaction, the twilight zone, the role of IP to investigate the matter in the twilight zone. That is what I mean when I say about the capability issue. Areas for improvement: IPs need to do an exercise of reconciliation of admitted claims to fair market value, whatever could be ascertained. I just go to the very brief. That means they have to identify what all the reasons. It is not possible that you can identify each and every reason, each and every reason, but broadly we need to do it. One more slide. Then giving utmost importance for custody and control, endeavor to file application timely with more diligence, to make sure transaction auditor, forensic auditor provide unambiguous reports without unwarranted disclaimers, reviving applications dismissed on the grounds of earlier venous judgment. I think this is something which the IPs, whosoever's applications have been dismissed, I think they need to take care to revive those applications. And IBBI and IPA focused research section to monitor the effectiveness of filing of avoidance transactions by IPs. Implementation of peer review mechanism, which is on the cards in some of the IPS, which is already there. Government of India amendments of provisions of IBC to make the burden of proof shift to ex-directors management when they do not cooperate and hand over all documents information needed by IPs. Explore the possibility of Companies Act 2002 be amended to make directors personally liable if they do not keep the books of accounts up to date, similar to section 300 of the Companies Act of New Zealand. There is a fantastic section at New Zealand. Explore the possibility of introducing amendments to give wider powers to NCLTs and NCLATs to summon any officer, director currently was working if there is a serious issue of non-cooperation for the process similar to section 244 and 157 of Insolvency, Restructuring and Dissolution Act 2018 Singapore. Capability building of at NCLTs. I think even the President NCLT, he mentioned very clearly about this aspect. Possibly bring regulation for the forensic auditor similar to IPs and valuers, so that there is some standard in the standard and more good forensic audit reports coming up in the future. Thank you. Okay, there are areas of further research. Thank you.
Sir, can you go to slide 20, just a second.
This one or?
20.
I don't see the number.
Yeah, that's the table here.
Yes.
I would like to open questions from the audience.
One second, I think it is not audible.
Sorry, you have mentioned about the forensic audit. Hello.
Yes.
You have mentioned about the forensic audit and regulation to bring in forensic audit mandatory. What I feel is...
No, I'm sorry, I did not say mandatory. I said regulation to for the forensic auditors also. Because I believe that forensic audit is not an absolute requirement to file avoidance of.
Correct.
That is my belief.
Yes, that is my submission also. It should not be a mandatory, because even otherwise, without the support of forensic audit also, IP is capable of coming to a conclusion that avoidance transactions have taken place and their application needs to be filed.
I fully agree with you. My mention was that to avoid the disclaimers, that is so. If somebody hires a forensic auditor, then IP should get a relevant forensic audit report, not with too many disclaimers. This is what I
satisfaction, but if he is satisfied, why he should
I agree with you.
Thank you.
I mean, in my cases, I have filed avoidance application and then attached the forensic audit reports subsequently. Because it is based on the evidence, not on the forensic audit report.
So this will be the last question.
Sir, there is so many orders in favor of the liquidator or the recovery of money, ex-directors. And the actual recovery is very less. Do you have any suggestions for that?
So we have a lot of laws, implementation is the issue. So I don't have any answer for this.
Okay, I have one suggestion. No questions. You have made a very good presentation and very nicely written paper. Only one suggestion. I think the suggestion which you are making your presentation is different from what there in the paper. So I would urge you that you just reconcile. I think.
Yes.
In your paper, one. Two, that would you also write something in your paper, or somehow you also enlighten the IPs who have drawn the applications into the Venus Gupta judgment, when the Venus Gupta judgment has been now clarified by the High Court itself, and I think that judgment is not in the review by the Supreme Court.
I think it is
in the Supreme Court, and there's Venus Gupta is also being cited.
Yes.
So hopefully that judgment also will come very clearly. So is this not a case that the IPs who have withdrawn or where they have been allowed to go out, should we file the avoidance applications?
In my view, yes. In my view, yes.
So could you not make a suggestion in this for the IPs?
Yes. I will be making. So I mean, after I have submitted my paper and subsequently there are some changes. I agree with you that that Section 300 and those New Zealand Act, I came to know subsequently. I will incorporate those things. And paper needs to be rewritten. I think I may have to consult some professors like Mr. Anirudh to get the inputs.
Thank you so much. Thank you.
So thank you all for the presenters, and I will also thank all the audiences for keeping the sessions engaging. So now I would like to honor the session chairs with the memento. So I would like to welcome Professor Shri Santosh Kumar Shukla sir to receive the memento. Professor Anirudh to receive the memento.